Can you hear me now, Wanda? Can you hear me? I can't hear you. You gotta type. I can hear you now.
Yes.
Awesome. Go ahead. Put yours on mute.
Put it on mute.
Because we're live. What happened?
If I put my, okay, I can still hear you if I put it on mute.
Yeah, exactly. Morning, Quelo. You're still on mute.
Good morning.
Yeah, exactly.
Okay, I can
Hi.
hear the both of you. You've been assigned to a breakout room. Could you go back to that breakout room until I summons you to the main room?
Sure. How do I get back to the breakout room again? Oh, I see it. Join breakout room. All right, no problem. Let me know. Particular questions you may have on her claim in the lower courts that the court may have concern with, but I really think that the main issue that we should be looking at is whether or not the Court of Appeal has or come to any realization that the actual application heard before the registrar, not having sworn her oath, could be validated by this court, or should it be that that judgment be set aside and we be given the opportunity to go right back to the Supreme Court to amend her pleading. And I don't know if you're there yet, but I would like to persuade you that that should be the position.
Well,
under
let's
the
start
circumstances.
that.
Okay, so if I can just take you, my lord, to my paragraph. Come all the way down. The very first paragraph that I speak to on the law is paragraph 21, and that is the law and pleadings. And then paragraph 22 deals with the strikeout rules, and the limitation is there about that issue and the effect of the registrar's non-appointment. This is towards the end of my skeleton arguments, but I can go through paragraph 27 is where we begin when we talk about the registrar's non-appointment.
Yes.
So it is submitted that it is a very serious time when no meaning is given to the articles and oaths prescribed by the public offices such as premiers, governors, ministers, justices, and magistrates. The fact the registrar never took the judicial oath to be sworn under the articles that give her the authority to act in a particular capacity should be a travesty within itself. If the court accepts the position that the registrar acting in the capacity of justice ruling should be deemed to be a decision made by the justice of the Supreme Court, then this court can give no credence to the need to take any such oaths of any office in our land. The court must ponder as to why the drafters of our Constitution thought it prudent to have oaths administered to bind individuals to the duties of their office. The Constitution enshrines a number of inalienable rights granted to the citizens of this territory. The right to a free and independent tribunal, unencumbered with obstacles, wherein an independent tribunal will determine disputes affecting the litigant's rights. And as you note, my lord, there has been a number of issues, pitfalls, just in the way in which Ms. Pedro's matter has been handled by the lower courts it's been a lot to leave a lot to desire. Ms. Pedro was a litigant in person, as you note, and throughout the proceedings, a number of warnings were given, even by my learned friend, to take caution as to her abilities or her.
But wait a minute, you're departing from what we're on. We can come back to that in a moment.
Okay, sorry,
but I understood we should. No, don't. We understand the background, and you know this is the second hearing of the appeal. Let's concentrate for the moment on your point that the decision of the registrar stroke acting judge was a nullity.
Yes. So paragraph A, the powers conferred on the Supreme Court of Bermuda and the Court of Appeal of Bermuda are found in the statutes creating and organizing those bodies. The functions of the office holders of those bodies are found in the Bermuda Constitution. The powers can be exercised only insofar as the exercise complies with the requirement of the normative rule immediately superior to the rule of concern. And so the normative rule that confers jurisdiction upon the Supreme Court is found in the Supreme Court Act 1905. Under any hierarchy of norms, it would not be possible for a power created by the Supreme Court Act to be engaged in declaring an act valid where the act or a ruling was made in circumstances where the constitutional requirements had not been complied with. And so the constitutional requirements are mandatory and hierarchically superior to the Supreme Court. Are you with
Forgive
me?
me, that sounds like a whole lot of jurisprudential theory. But,
well, my lord, it's almost saying that without having your judicial office being solidified, everything that you do is now no longer of force. Just like if the premier it doesn't take his oath, and all of the legislature refuse or don't take their oath, and the laws are to be passed, and these persons are to be known to or are supposed to be able to be tied to office, they don't become a part of their office.
Wait a moment. I mean, what I understand you to be saying by this invocation of the hierarchy of norms, put in simplistic terms, is that if the Constitution, which is at the top, requires something to be done, then that must be done, whatever view the common law might have taken, or possibly whatever view a statute expresses.
Correct, because the highest—
That's what it amounts to, isn't it?
Correct, and the highest order that we have to follow would be that particular document. We cannot stray away from where we derive our powers and our laws from, or how in which our powers and our laws should be delineated. And that is enshrined within our Constitution, unlike common law, unlike the UK, where there are a number of documents that provide these particular protections. We have one. And without following those particular guidance or following the what has been laid out, we would be a jurisdiction of just do it whatever comes to mind or however we feel. And then there would be no consistency of justice. There would be no consistency of normality. There would be no consistency of office, or even giving power and credence to that particular office. And so if we are to ignore now, under the circumstances, some in this inalienable right, and particularly when it comes to the Supreme Court, because remember, this is an institution that must be held to this highest standard, because the result of it is very paramount to individuals who present themselves. And so without it, it means nothing. So it's just not as—
okay, I follow all that, but ought we not then to look at what it is that the Constitution provides?
Absolutely, my lord.
Section 6.
Article 6, my lord.
No, I'm so sorry. Article 6.
It's Article 6, my lord. And I will pull it up for you.
It's the right to a fair trial by duly constituted tribunal, is it?
Correct. Any person who immediately— yes, my lord. Let me just move into the articles. Protection of law, the provisions to provide to secure protection of law.
I'm sorry, I've lost. What are we looking at?
The Constitution, my lord.
Yes, can you give me the relevant paragraph and subparagraph number?
Yes, my lord. It's paragraph 6. It would be Article 6, provisions to secure protection of law.
Yes.
Oh,
and
sorry.
Which subparagraph?
Give me 1 minute.
Are you looking for subparagraph 8?
Yes, my lord, I'm just going there. Sorry.
I'm sorry, I just need to know which is the one you're referring us to.
So it is subparagraph 8.
Yes.
Any court or other adjudicating authority prescribed by law for the determination of the existence or extent of any civil right or obligation shall be established by law and shall be independent and impartial. And where proceedings for such a determination are instituted by any person before such a court or other adjudicating authority, the case shall be given a fair hearing in a reasonable time.
Yes. Right. But then we need to look, do we not, about what the Constitution provides in relation to acting judges. Which is, we start at section 75, subsection 2. Have you got the
I do have the Constitution before me.
have you got the folder that
Is it the authorities bundle you're referring to, my lord?
well, it's a supplemental authorities bundle with a yellow front page.
Yes. Because I prepared to having the documents before me in electronic form.
Okay.
So that I can easily scroll down to it. But I do have the bundle with me.
Well, I don't mind where you look at it, but what we need to look at is section 75 of the Bermuda Constitution Order.
Yes. So acting judges of the Supreme Court. The rules say, well, the Constitution sets out that if the offices of a justice is vacant, or if the holder thereof is.
So wait a minute. There's no need to look at subparagraph 1, because that deals with the office of Chief Justice.
Yes. So we're talking about.
Are we not thinking about the office of Assistant Justice here?
I don't think we are.
We're speaking of acting judge.
Appointed as an acting judge or an assistant?
He was appointed as an acting judge.
She was appointed as an acting judge, my lord. Well, she says she was appointed as an acting judge, but we now know that she hadn't been appointed at all.
She had no, you're wrong about that.
She was appointed.
The governor had signed an instrument of appointment.
Her instrument of appointment, my lord, was for registrar, what I've received.
No.
I think it was as assistant justice.
Just a moment.
Can Mr. Moodie assist on this?
It certainly was. The instrument was signed by the governor, appointing her as an assistant justice for a limited time. The only defect in the appointment process was whether or not she swore the oath of allegiance or judicial oath.
Well,
that's a different matter. But it was as an assistant justice, was it?
Yes. Well, let's be clear about this. Have you got, the papers in this case are all over the place, but there is a document dated the 28th of May 2019, which is headed Outline Submissions for the Intended Respondent. It's on the cloud.
Is on the cloud? Let me go to that document. Respondent summons, respondent skeleton arguments. Is that mine? I see submissions upon the applicant. Okay, I'm opening that one, my lord.
Well, if you go to the last page of it, have you got the instrument of appointment?
I have. Just trying to get to the last page. It's loading, my lord. Give me 1 minute.
Yes, they're a bit slow, I'm afraid.
Yes, so do apologize.
No, don't. Nothing to apologize for.
So the very last page of these submissions, my lord, you're saying?
Yes.
Okay. Are these submissions written in green?
No, I think you're looking at Mr. Hill's submissions. What you should be looking at is a bundle entitled Outline Submissions for the Intended Respondent. A physical bundle, I think, was prepared and filed in court. which has 7 tabs. And on the final page is the instrument of appointment that was supplied to the court by Mr. Coelho, actually. Mr. Coelho, I think, sent it to the court on Tuesday, April 21st, in the event that he can assist you in locating it.
But it is on the cloud.
I'm looking on the cloud, my lord, and I see one document that says outline submissions of the applicant.
Yeah, no, the first document on the cloud is outline submissions for the intended respondent.
My lord, I can tell you what I have on my cloud, and I have writ of summons, rule of Supreme Court, respondent submissions. I have respondent skeleton arguments, Pedro's report, outline submissions of the applicant, notice of the appeal, notice of motion, not sure what this is called, judgment of the Supreme Court, informal transcript, first
Well,
affidavit.
there's no point in...
I don't have that. I don't see that document on the cloud. I'm sitting on the cloud.
Well, that appears to mean that the documents that you have on the cloud are in a different order and not the same as those that we have on the cloud.
Okay. All right. I see another? I do see another folder. Is it tab 7?
Yes.
Okay.
Wait.
I do see here. Yes. So His Excellency, I do see the
Yes.
Alexandra Wheatley.
Do hereby appoint you, Alexandra Wheatley, to act as a puisne judge of the Supreme Court, to act as a puisne judge of the Supreme Court for the period 19th September through 27th of September, or until such time as you finalize your judgment, as envisioned by the proviso to section 54 of the Constitution. So it's plain that was executed on the 16th of September 2019. So it's plain that His Excellency has appointed Miss Wheatley to be an acting judge by signing the instrument of appointment, which we can now see.
We should note, though, that it invokes section 75(4). Yes, which does deal with acting judges.
Yes.
Yes.
Ms. Smith, you've muted yourself. I don't know whether intentionally.
Hi, good morning. I'm sorry. My apologize.
Hello.
Yes, but my lord, I was saying that so the issue that we have is that her actual for the particular time when the order was made is what we're having issue with.
Yes.
So, I mean, my position when it comes to with this particular issue is that if she had not, for when the order was made, not been constituted in the proper manner, should the position be that that it should be acceded to, or
Well, wait a minute. What was the date of the hearing? Was it the 25th of September?
I think it was the 24th, my lord.
24th of September.
Right. So she sat during the period for which she had been appointed as an acting judge. The appointment was for that period or until such time as you finalize your judgment. So she remained an acting judge until she finalized her judgment. The fact that the judgment was after the 27th of September is neither here nor there.
Yes, my lord. This is the position, seems to be the position, my lord. And so if it is that now the position is that, the position is that she has been constituted in the correct manner.
Yeah.
For her to act under the circumstances. We can only draw now our particular position in relation to the actual judgment that she would given in relation to the striking out application.
I don't understand what you mean.
No, well, the point was the position that my learned friend espoused to the court was that she had not been constituted in the right manner, having not been sworn. And
Now that's
subsequent,
Yeah.
go ahead.
Okay. Yeah, no, go on.
And subsequently, we have proof of the oath of assignment being levied again for her for that period of time. So now is the court's position that she was constituted properly. Yes.
Yes.
And that her judgment would be also considered constituted properly because she would have had the position as judge, correct?
Well, we haven't reached a decision, but I mean, that's what could be said.
Well, my lord, if without the instrument, I mean, with the instrument, it gives credence to the rule.
Sorry, gives credence to which
Isn't
rule?
To her appointment, to the
Look,
validity of her appointment.
The argument that has been addressed before turns on section 76 of the Constitution. Have you got that?
Yes, I do.
That
taking of the oath.
Before entering upon the functions of his office, every judge of the Supreme Court shall make and subscribe before the governor or some other person authorized in that behalf, oaths or affirmations of allegiance, and for the due execution of his office in the form set out in the first schedule. And the point that has been made before is that the registrar had not sworn an oath in accordance with the first schedule in her capacity as acting judge. She may well, and she must have sworn an oath, and indeed her evidence is that she had sworn an oath as registrar.
But not as an acting justice.
But not as an acting judge.
And so, if the position is that she has an instrument of appointment, but not taken her oath, the question now becomes, does the oath, the failure of taking the oath, negate her position in relation to her office, having sworn this document?
That does become the question.
That is the question for the court, as far as that's concerned. And so my position, my lord, is that without the sworn or without the attestation, so my beginning point of about the attestation has only been based on the fact that once you go through the process of taking your oath and you are now bound to your office and duty, then you now are constituted. So is not the court's is it not the next position to take within the law that without being bound and constituted, all orders or all decisions made must be ultra vires?
Well, that's your point, and that we will have to decide. But what might be said against you in relation to that is this. It looks from section 75(1) as if the appointment to the office occurs when His Excellency signs the relevant instrument. And that could be said to be confirmed in section 76, because that begins by saying, before entering upon the functions of his office, which contemplates, or could be said to contemplate, that he's already got the office, and 76 is determining whether or not he or she should enter upon the functions. Now that begs the question as to whether somebody who has been appointed and who does not swear the relevant oath, although in this case the registrar had sworn an oath as a registrar, which, except for the difference in title, is exactly the same as the oath for a judge. That begs the question as to whether a failure to swear the oath when you have been validly appointed is fatal. Have you looked at the case, the Margate Pier case?
I will draw your attention to that page. In the Margate Pierre case, my lord, when I
Yes.
read the judgment, and many of these cases are pretty much indicating that once your office has been constituted and it's on the same standard or level, and I would like, for a lack of a better word, is do you accede to these particular positions? But when I look at the difference between and how in which appointments are done within this jurisdiction compared to how the appointments are dealt with in our jurisdiction, I still find the last step of the oath relevant
Well,
or
yes,
necessary. Because
yes,
in
yes.
the
Well,
UK, okay, go ahead. Sorry, my lord.
well, shall we look at it?
Okay. Which
Because-
paragraph would you like me to refer to first?
Well, it's on the second page. The judgment of the Chief Justice begins about halfway down the page. And there's a paragraph beginning the second question. Have you got that?
Yes, my lord. The second question was spoken to at. Yes, my lord?
Yeah. It arises in this manner: by an act of the 51st of His present Majesty, His Majesty is authorized to issue a commission to be directed to certain persons to be therein named, constituting them to be justices of the peace within and throughout the liberties of the Cinque Ports,
Yes.
and investing them with the same power and authority as belongs to any mayor, bailiff, or jurat to exercise within the liberties of the town whereof he is mayor, bailiff, or jurat, and from and after such commission or commissions shall have so issued, all person and every person named in any such commission shall be, and they each of them is and are hereby declared to be justices and a justice of the peace, etc. So your appointment arises when the king issues the commission. Yeah.
Yes, my lord.
Then it says, by the third section of this act, it is provided and enacted that no person or persons to be named in such commission shall be thereby or by this act authorized to act as a justice of the peace, unless he shall have such qualification as will authorize him to act for a county, and unless he shall have taken and subscribed the oaths and delivered in at some general sessions to be holden in some one of the Cinque Ports, the certificate respectively required to be taken and subscribed, and delivered in persons qualifying themselves to act for counties. The defendant had taken the oaths under a writ of dedimus potestatem, but he had omitted to deliver a certificate or take any oath at any general sessions in any one of the Cinque Ports. So this was a man who had been appointed by the king as a justice of the Cinque Ports, but had not taken the oath required by the relevant act. And the court said, we are of opinion that notwithstanding this omission, his acts as a justice in the matters in question were valid. And then they go on to say that this sort of objection can arise in a whole series of cases. And at the top of the next page, they go on to say that there are a number of dreadful consequences if the act of the justice is invalid on an objection such as the present, including that a constable who acts in accordance with their directions may find himself liable to a charge of murder. And about 12 or so lines down, the Chief Justice says, an exposition of these statutes, pregnant with so much inconvenience, ought not to be made if they will admit of any other reasonable construction. Acts of Parliament, says Lord Coke, are to be construed as no man that is innocent or free from injury or wrong be by a literal construction punished or indamaged. We think these acts do most reasonably admit of another construction. We think the restraining clauses, that's the third section to which I referred, are only prohibitory upon the justice. By the particular act upon which this question has arisen, Mr. Dyson, having been named in the commission, is declared to be a justice and invested with power and authority as such. The proper effect, therefore, as it seems to us, of the third section is only to make it unlawful in him to act as such, but not to make his acts invalid. So what may be said is that in interpreting the Constitution, so we're not dealing with something of an inferior norm, but the one thing we do have to do is interpret the Constitution. We alone can do it for present purposes. What could be said is that whereas if the registrar had never been appointed as an acting judge at all, it may be, this is debatable, that the de facto common law doctrine wouldn't have saved the position. If she has in fact been appointed, but has failed to swear the relevant oath, that is not fatal. And indeed, the provisions in this act were more onerous, because the third section said that no person named in the commission should be authorized to act as a justice of the peace unless he has subscribed the oath. Whereas here it simply says before entering on his office, the judge must swear the oath.
My lord, but in these particular circumstances, we're looking to keep up the integrity of these offices. And I do absolutely appreciate that once, in some of these cases, as a position is that if you are considered a justice, or you would have been put in a position, but find yourself in default of no longer being in a position in the UK, that your position should be attested to, or that we should allow any judgment to stand for as valid. But in the circumstances, because we have particular steps, just as they set out in that legislation, and without being able to swear your allegiance or take your particular position, what credence does that give to all of our other offices? And so what we're saying is that if you are an oath means nothing at the end, or particularly to this particular instance of office. It means neither here nor there. Either you have an instrument of appointment, and the oath is of no consequence at the end of the day. But the oath, in the words of what you're attesting to, is your allegiance to do right by the position or the office that you've been granted. No.
Mm-hmm.
So if we are to uphold the sanctity of these offices, we are now going to take the position, this is going to be law, that there's no need. So how do we?
Not that there is no need.
Oh, but that is of no consequence, though, my lord. Because
yeah.
if we, there would be no consequence. There would be of zero consequence. So there would be.
Well, there would be no consequence of invalidity.
That's my point. But but the office itself gives the validity to the judgment. No, every decision made by the Supreme Court is validated by that it is before justice, and that the decision is of that particular court. And so, Section 75 in itself, where it says, and if we go back to 76, and it says before entering upon the functions of this office, right? Before you enter the functions and actually can do what you do, every judge of the Supreme Court shall make and subscribe before the governor or some other person authorized in that behalf of the governor, oaths or affirmations of allegiance. Shall.
Yes, but I'm afraid shall begs the question as to whether it's mandatory or directory.
Well, I beg to say that in my particular position, my lord, that is mandatory, because shall in every other legislation is deemed to be mandatory. He shall. When we look at the definition, or when we look at any instrument, any legislative instrument, we note that if it say may, it's not a definite, but if it says shall, it shall be.
Well, I'm not sure that's right in every case, and we are encouraged now to abandon the distinction between mandatory and directory, and simply ask ourselves what consequence Parliament or Her Majesty intended
In relation
passing
to the
relevant
oath.
instrument.
Absolutely.
Are we entitled to take into account, as the Chief Justice did in the Margaret Peer case, the consequences if you are right, which include the fact that a registrar who sits as an acting judge in divorce proceedings may grant divorces, custody orders, maintenance orders, and the like, which, if your submission be correct, are wholly void, so that people who thought that they were no longer married turn out to have been.
In our jurisdiction, because
Yes.
in within our jurisdiction, when these divorces are granted, our registrar does make particular orders, but our divorces are granted by or signed. Have you seen in the decree by a judge? No?
Precisely. Such that if the judge who signs the divorce is an acting judge who has not sworn the relevant oath, the parties who think themselves to have been divorced will find, possibly years later, that they remain married.
Yeah, I absolutely accept that particular point, my lord. But in the circumstances, or in these particular circumstances, when we're looking at what constitutes the person to have that office, I mean, what result? The only result, or that to fix the irregularities behind that, is for that particular issue or matter to be addressed by the court, and then acceded to say, yes, these divorces were proceeded in a particular manner. And yes, this person could be. I'm saying that the divorce itself would have occurred and been sanctified, sanctimoniously accepted by the court as done. And then the court would have to go back to try and address these issues in that manner.
And do what?
Well, my lord, I mean, if the actual order needs to be signed by a justice, can it be rectified by her taking an oath thereafter, or can the justice be rectified by taking an oath thereafter to remedy the issue? Does taking the oath, just being able to administer the oath for the actual instance, right? Then to sign the order and then give it credence.
Well, you tell me, can we solve all this problem by asking the registrar now to take the oath?
Well, under circumstances, I think at this point, that's already passed, no? If that was the case, it could have been done then.
Well, is it the case? I mean, are you saying?
Well, I take the position, my lord. I mean, in the UK, I've read all of these cases, and the position in the UK is that we should not subscribe to not giving credence to these orders just based on certain finalities. But in the Bermuda, if we look at it that way and we say, well, because this oath hasn't been administered, or because this hasn't been done, is we're giving nothing but de facto positions in relation to the office. So again, we're in a catch-22 situation. I totally understand the administration point. Should we now say all of them are not divorced? But we should say that they were not valid, because the validity of the office is the most important part.
So your answer is yes, we should.
We should.
Yep.
We should.
Okay.
Because if we don't give the direct attestation, or we don't give the power, and where the power lies is by the oath, then the document has no power. Yeah. It has no power. And for you to enforce that then later and find out it had no power, it makes the whole thing null or outside of the law. Okay. And should we continue on that particular position that we say, okay, everything is fine, we're going to just, we will just whitewash that or accede to that. And then there's no constitution power of the law of these oaths at all. So there's no real credence of it. If you're a registrar, you're a judge.
Okay, so you're essentially, you say that if we were to adopt the approach that I was considering, it would mean that the oath was of no consequence, and that can't be the right interpretation of the relevant section of the Constitution.
Absolutely, and that would be to all offices, my lord. That wouldn't be just to justices' offices. That would mean that we now are saying the law is that if you do not take an oath of office, because this would be used in support of evidence, in support of other applications that may come later, that should not bring any.
Okay.
And
what about the de facto doctrine? Do you say that's simply inapplicable
in this circumstance, in the constitutional case, because where we find our powers in the UK for these justices are from the statute and different positions laid out in common law. All of these cases.
Yeah.
We have the luxury. Correct. We have luxury of having a written document that says exactly what should be done under the circumstances, and why that is because we need to make sure that each person who's given these positions take it seriously enough so they are doing exactly what they're mandated to do, and to be fair and to be honest and to provide. And not saying the registrar's oath is any, even though it's not so different from the justice, but the way that the legislation is set out, justices and registrars are different.
Well, it's actually not. The oath isn't different at all. Save that it substitutes for the word registrar the word judge.
I understand.
There's a slight degree of unreality in saying it's very important to have sworn the oath when one knows that the quote judge close quotes in question has sworn an oath to do all right by all manner of people, etc.
But we accept that the registrar has a different role than a judge.
Yes, yes.
Okay. And so if the role is different, then there must be there is a difference. They're not the same, and they will never be the same.
Well, the roles will never be the same.
Never be the same. The oath is the same, but the roles are not the same, and they cannot adjudicate on the same things. They can adjudicate, the Supreme Court justice can adjudicate on everything, but the registrar cannot. And so, oh, sorry, my lord.
What relevance is there in the fact that in this case, although the registrar was sitting as an acting judge, she could have in fact have sat as registrar?
But that's not what the capacity was she indicated, though. I mean, she
I
could
know
have.
that.
Yeah, but
I know that.
But as far as the application is concerned, right? When the application was made, and this was, and how in which the application was made, this also would have been, I mean, I know that my client would have made issue with whom it should have been in before of and all of those extra sideline things. But the judgment in itself was given under the circumstances that she was just a judge or act in the capacity. And we're looking at, particularly with strikeout applications, and whom they come before when dealing with strikeout applications. Usually direct inserients are dealt by registrars. So remember how the summons was filed. The summons was filed for directions, and then was advised that there was going to be a strikeout application. No affidavit supporting the strikeout application. So the irregularity therein, it was already glaring from the beginning. And then when the application comes, it's filled with additional information. I mean, although that's a different point as far as guerrilla.
We can come on to this, but what has this got to do with the simple point that I was asking? Is it of any significance that the registrar could have sat as registrar?
Well, my lord, I take the position that the application for strikeout would have been before the justice, as it was settled to be before the justice.
Yes, yes. I think the short answer to my question is you say it's irrelevant that she could have sat as registrar.
It is irrelevant.
Yeah.
Because it was leveled to be. Okay, sorry, my lord. I'm trying not to.
I'm afraid I'm a very simple mind.
I'm trying to expect these tricks. I apologize.
These tricks, did you say?
I
apologize. There's no trick in my questions. I ask for information.
I do apologize, my lord.
Oh, no, nothing to apologize for. Right.
But my lord, you are with me in relation to the position that we cannot continue to subscribe to or use the de facto position when looking at how we have registrars making decisions, Supreme Court making decisions, or whether or not she had been constituted. I think
I'm with you in the sense that I understand exactly what you say.
Okay, I'm obliged, my lord.
Neither party should expect any expression of view from the court until it has heard all the argument and reaches a judgment.
My Lord, have you had an opportunity to look at Shabir in the state, a ruling made on the 6th of December, the case that I put in my submissions, the Allahabad High Court?
Ah, yes, I have. Yes.
Right? And so it very clearly sets out, and they have, I use the case as an example of how things are meant to be in order. And paragraph C really sets out, say, we will deal with the submission certain. Article 219 of the Constitution reads, every person appointed to be a judge of a high court shall, before he enters upon his office, make and subscribe before the governor of the state of some person appointed in on behalf by him on Shabir versus on the sex of the Indian Kunan. This is his salutation, oath or affirmation according to the form set out for the purpose of the third schedule. And so they have their constitution and following the particular position that this is important. Has to be assumed to. You don't take your office. You are not a judge unless you have this oath. Same would apply in our circumstances, because it has set out there in our constitution for this to particularly take the position. And unlike the UK, where there is no written constitution, in India, there is a constitution that they must follow. And it sets out it gives that credence. And they go on to say, it admits of no argument that a person appointed to the judge of a high court can only enter upon his office after making and subscribing the oath required by the law. It is the performance of the oath that marks in the induction into office. It would be noticed that Article 219 of the Constitution uses the words every person appointed to the judge of high court, and not every person appointed to the judge of a high court, which would indicate a person appointed to a judge becomes only after the oath has been subscribed to by him.
Well, that may be the critical distinction, because as we were looking at previously, the registrar became an acting judge, wouldn't become one by swearing the oath, but became one because of the governor's appointment.
Correct.
And that may be a critical distinction. And as they say in the passage that you're referring to, Article 219 uses the word every person appointed to be a judge of the High Court, and not every person appointed a judge.
Correct.
And it could be said that the effect of section 73, no, I'm so sorry, section 75, is that the appointment took place when the deed was signed. And 76 doesn't actually say that the judge can only enter upon his office after making the oath, but simply says before entering upon the functions of his office,
right,
every judge shall make the oath.
But what are the functions of his office, though? Yes, I do appreciate that, my lord, but the functions of his office is to adjudicate on matters, no? Right? So his whole function is to hear evidence or hear pleading submissions and make a determination best to the ability of his office. So
but if you were to ask the registrar, no, not the registrar, if you were to ask a lawyer the day after the governor had signed the instrument, whether the registrar was then an acting judge, the answer would be yes, she is, wouldn't it?
I would, if it was a good lawyer, they'd read the Constitution and see if she had to do something else, which is section 76.
Right.
No, because Mr. Hill took the point, saying that without having administered the oath, and clearly that was a part of the office, that she was no judge. She was still the registrar.
Right. Right. Now, let's see where we are.
Yes, my lord.
let us assume that those submissions are well founded. You say, as was once common ground, that the decision of the registrar is a nullity.
Yes, my lord.
It's as if it had never been made. Now, the position that we had reached at the previous hearing, when it was common ground that the decision was a nullity, was that for that reason, the matter would have to go back to a judge, not the registrar, and that it would be necessary for the pleading to be amended because the pleadings are all over the place at the moment, upon the basis that when that had been done, the judge could then decide, if application was made, whether or not the pleading should be struck out. And I think I suggested that in circumstances where it's plain that the respondent is taking the limitation period point, that it might be sensible for the claimant in any amended pleading, as opposed to waiting for a reply, to set out what is the answer, if any, to the Limitation Act point.
Absolutely, my lord. And I
Do
think
you-
I've somewhat succinctly set out what her response to the limitation was, because there was an application, a further application for custody that she would have made to the court later on, because my learned friend takes it that this would have been ended in 2000 in a particular position. But when we look at the applications that she made or attempted to make, it would have put her within the time period for her to bring her application. And even though she might have been found to be out of time, she still could have made an application for the court to look at it. But she had not even been given the opportunity to amend her pleadings, right? To provide that detail when the court was looking at the striking out application. Because if you heard and if you listen to the actual proceedings, my learned friend would have brought up the information saying that all the evidence wasn't before the court, and the information, because we see the pleadings, my lord, you see the pleadings were completely disjointed and not proper in any event. And when you're dealing with a litigating person, much like how the Nanette Snowden case is dealt with, there were many amendments done. The court still would have given the opportunity for her to amend, to put her case as best as she could in order for you to determine whether or not it is of substantiation. And she had not been given that opportunity at all.
Well, let's take it in stages.
Yes, my lord.
If one considers what the pleadings need to do and effectively don't do, I mean, the first question would be what is or are the cause or causes of actions relied on?
Yes.
And there's a great splatter of allegations
Yes.
in what passes for the pleadings. We were told last time that the cause of action that is sought to be relied on is misfeasance in a public office. Is that right?
It was misfeasance, and well, a part of the application was misfeasance, but the main application was in personal injury for the mental anguish that she would have.
No. Wait a minute. Personal injury is the damage. One has to take these things in. You can't recover anything, can't recover any damages unless you have a cause of action.
That's correct, my lord.
So literally the first question is, what is the cause of action?
Yes, my lord. And it would be the position that there has been some misfeasance in office by the persons who operate within the judiciary. And as a result of the
Wait a moment.
Oh, sorry.
Misfeasance by persons who operated within the judiciary.
And also agents, my lord.
And also what?
They're agents. So the process of how in which the manner her case was dealt with, by whom or what was done within the case, and how she may have been stopped from asserting such claims or utilizing her opportunities through the court to assert her
Well,
application.
wait a moment. If you're relying on misfeasance by persons operating in the judiciary are immune from suit.
The process in itself, my lord. So with the office itself, the person itself is immune.
Yes.
The office itself is not immune to any litigation or you saying the actual procedure. So she's saying that based on the way in which the procedure or the way in which things were handled in her matter, right? And the bar to her getting fair trial and the bar to her being able to accede to her applications or making her applications, she has suffered damage. Irreparable damage, she says. And based on the information that is before the court or that had been before the court, and you can hear in the recordings and you can see through all the information that there has been some, it was obvious, not obvious, I will say, because that's for the court to determine, but there is an arguable case that things did not go as they should have.
I'm sorry, I'm simply not following this.
Okay.
Appears to suggest that if I make a hopelessly incompetent mistake, I am personally immune, but the state is liable.
Correct.
Not possibly very right. What?
Correct. What do you mean, my lord? If you are aggrieved by the state by a decision, you can go and do a judicial review. And if the state is wrong in making their decision, then you get damages, no?
Well, this is not a judicial review.
No, my lord, but what I'm suggesting is that many of the actions that she is saying were actually intentional actions against her. We have to think, my lord, that there were some instances when personal issues would have arisen in the determination through these matters, or not personal, but a particular position would have been accepted or taken in relation to her matter step by step, from the beginning to the end, just in which the case was handled from jump to the end, even when she went to apply for legal aid. The position.
Wait a minute. In order for there to be a cause of action, there has to be a tortfeasor. This is not a breach of contract case. Right. Who is said to be the tortfeasor?
Would it not be the state?
The state?
Well, if it's not the judges personally, my lord, if we're saying that the position is that the judges personally, but their office can be, then it's their office. It is their positions. And then you bring evidence to show that they have done some misfeasance, or there was some misfeasance in relation to what has transpired and now and my damages. You have, I know that it's very creative. Pardon?
Yeah, this is all rather new. Is the suggestion that the magistrates were guilty of what would be misfeasance in a public office if they weren't immune from it, and because they're immune from it, the state is liable? They
are agents.
Sorry, that's not an answer to my question.
I'm sorry. I have to say yes.
They're not actually agents.
Well,
they're officers of the crown. I don't regard myself as an agent of the state.
That's true. But the crown is whom we are suing. Right now we are in an appeal saying that an action must be brought against this institution, whatever you call the institution.
So can I make sure, it's important that I get this right. The magistrates were guilty of misfeasance of office, but they are immune.
Personally.
So the state is liable.
Oh, the crown.
Okay,
if you call it, that's the state. Whichever you want to call it. Well, we don't have a state in Bermuda, to be honest. So Bermuda's not a state.
Okay, so the crown is liable.
Correct.
Anybody other than the magistrates?
You
And
can,
you've given
I
up
know.
against the magistrates upon the basis that they were immune.
Well, actually, my client would have had requested, given upon the magistrates in a personal capacity, but my clients did request to have them re-added to the application, which you would have to deal with on the lower, on the below. And I understand that we're going through this process now to discuss it. But she says, and
You
this is her.
can't keep doing this, adding them, taking them away, adding them back.
No, my lord, I'm not trying to be. I wasn't the lawyer first, my lord. I'm coming to clean up this problem. I'm trying to help this client get her justice in some fashion. And so I'm trying to make sense of the issues. There are issues. There has been damages suffered. And we're now trying to determining what is the best route for her to seek justice for what has transpired. And the persons who aggrieved her is a magistrate. The people who aggrieved her are agents of the crown.
And who are the people who are the, well, sorry, wait a moment. I'm afraid I'm a
Would you like me to list their names? I can list their names for you, my lord.
No, but let me finish the question.
Yes.
You refer to the magistrates, and then you refer to their agents. What
Correct.
type of people are these?
They are clerks.
They're clerks.
Yes, they're clerks. They are assistants to the magistrates. Would you like me to name them for you, my lord?
No, not for the moment.
Okay.
Anybody from the DCFS?
My lord, Department of Child and Family Services.
Yes.
They are only, I do not believe that they would have thwarted her justice. They may have been complicit in the information provided or failed to do certain things.
Let me understand. Are the clerks said to have been guilty of misfeasance in a public office?
They would have been used, yes, to enforce, to cause misfeasance. Because if you look at the wording in their email, or there's one particular email that I add in my skeleton arguments that set out that she's not to make an application to the court unless she was present. That's not the case.
But I mean, the notion that that is misfeasance in a public office is absurd.
Do you think so, my lord? For
Yes,
you to
I
be
do.
told, well, I don't agree with that, my lord. I'm sorry.
Yes, okay.
I
Okay,
apologize.
but anybody other than the clerks?
This is new. This allegation about the
Yeah.
clerks being guilty
Well-
of misfeasance. I didn't quite get how Miss Smithville frames that argument. How do you
Well,
say they're guilty of misfeasance?
When the applicant would have made her application to the court, they were used. I said she was used. She expounds in her email that the magistrate clearly says she cannot make the application unless she has a lawyer in Bermuda or she's physically present. So you now know she doesn't have the right to file her application for her care, custody, care, and control. She files her application and she wants to have access and custody, care, and control of the minor child. She's now making further applications that she had made from the beginning to get custody back of her child. And they were told in the email, it says very clearly that you either to have a lawyer or you must be physically present. That is not the position. The position is she can make her application remotely if she wishes. She has to have access to justice. And
She was heard.
Go.
There's a transcript of the hearing. There was a fairly extensive hearing. She was heard.
When?
remotely.
That was before. That was
No, sorry.
Sorry. Can you?
Sorry,
I
I'm
do
muted.
apologize. Please. It wasn't the same time, my lord. This is after. We're talking about this. That was earlier. So there was one occasion when she was, but then subsequently she was told she cannot make the applications any further.
Yeah.
So it did happen subsequently.
And you
so
say
I'm
that's
saying,
you say that's misfeasance, do you?
well, I mean, you don't have access to justice, my lord. What's worse than not being able to have access to justice when you only know the place for you to go to get this access for your child is to the magistrate's court, because that's where it's been dealt with. That's where it is. That's where you have to put you. We say that she's wrong. She has fatally caused herself because she had acceded to this position and then she didn't make any further applications, but she did. She didn't make any appeals, but she did, because she only knows what she knows. She's a litigant in person. And if you could see the earlier cases she may have had an attorney, but during these later applications, she was representing herself. So that in itself should have given rise to the court to take more caution for her. More caution for her application. Whether they, and I just want you to understand, my lord, that I know this sounds very far-fetched in some circumstances, but the way in which she had been dealt with as a litigant, right, leaves a lot to desire, because the things that people had said or that were saying during her case or during her applications were like she was some vexatious litigant and she was just getting on everybody's nerves and she just was being overt. But this is her child.
Can we keep on the topic? You say there was misfeasance by the magistrates, by at least one clerk. Anybody else?
Her claim is really about what took place in the magistrate's court, my lord. And it was only one particular magistrate that was dealing with her matter. And then her only other issue that she brings up is that her access to justice was indeed was additionally thwarted in other instances. But that's only an icing on the cake. That's only to show that she had went through so much just to get here, just to be even here today.
Wait a minute. I've written down her claim is mainly about what took place in the magistrate's court.
Well, the decisions. Well,
yes, the decisions. You may find that if
and her not being able to make her applications, my lord. Because she remember the very last application she sought to make, she couldn't make it. She was denied that option. So she applies then to the Supreme Court to bring this case to court, to bring light to what her injustices had been experienced in the magistrate's court.
Wait a minute, just let's keep on the same topic. If the position is, which does not appear to have been the position that was taken before, that her claim is about what took place or didn't take place in the magistrate's court, you may find that that whole claim is held to be wholly invalid, A, because the magistrates are immune, B, because the state is not liable for the immune magistrates' activities, and C, because there was no appeal in relation to the orders that were made. What I had understood from the extremely lengthy writ previously issued was that the complaint was against members of the DCFS.
Yes, that was my understanding too.
Are you saying that's not the complaint?
And my understanding as well.
My lord, she had a claim against all of those persons.
All
Her
of which
claim was
persons?
The magistrate, the clerks, and the Department of Child and Family Services in failing through their investigation, because they had no investigation in relation to the allegation. And this was just a series of all no evidence and no information and just emotional orders that ended up in resulting in what she suffered at the end of the day. So we have to look at it in the totality of what took place.
Well, you may do, but if in fact you have complaints against A, B, and C, and the complaints against A and B are impossible to bring in a court of law, it would then become necessary to see what, if anything, was the effect of that which C did. Do you follow?
Yes, my lord. And,
well, okay,
what would have been a result in her damages? Sorry.
What?
If I might, as I understand the case previously put, the reason why the limitation argument arose and had to be addressed was because your client had said she had not discovered the misfeasance until her return to Bermuda sometime later when she was going through the files. And that became the base upon which she pleaded the exception to the limitation defense.
There's also, after I would have looked through the information, the very last applications that were made to the court. And that would have, from that time when the case was shut, when the door was shut on her, would have been the time that the time would run, because you have to do it within the time. You have to have a knowledge of your damages. And she became aware of her damage maybe later on, but suffered from the time that she was denied access to the court. So that's within the limitation period
Going to
of
the
what
question
my
of-
learned friend was arguing. My learned friend argued that the limitation period was under those 6 years position. And so I was trying to address how we could address that point by saying that this is what the actual start date should look like. And it would have been in time for her to have bring her application when she did. However you look at it as far as the limitation is concerned, but that was what my learned friend argued about the time frame for the limitation. And now I
address my Lord President's question about the identity of the tortfeasor. It was because of what your client said she discovered from the files that led her to the view that the DCFS had been involved in a conspiracy.
Correct.
Against her.
Correct.
So who do you say are the tortfeasors?
Well, that would include the DCFS, my lord, because we're talking about every person who would have been involved in the action. And I do note, I take the position of the court as far as the court is concerned, but there must be a position where that if it's proven or that it could be proven that misfeasance had taken place by any person who was in their office, whether or not they are immune, is it that there is no, how do I say, relief that can be gained as a result? And it should just be that accepted as it is, and there's no claim that you can make.
Well,
because that's pretty much what we're almost suggesting in a sense.
yeah,
And
but
I
I'm
want
afraid that's
to,
very vague. Where we've got to is that your case is that there was misfeasance by the magistrates, the clerk, and the DCFS. But what exactly, I mean, that's the first question, what is the cause of action? The next question is, what are the facts which are said to constitute the cause of action? In other words, what was done or omitted to be done?
well, my lord, is it for us now to determine this, or is it for that to be determined by the Supreme Court justice? Because really the whole point of this is for us to say, she be allowed to amend her claim, put it to the court in the right manner, and let that be examined by the justice, whomever is going to be to deal with it, and for them to determine, is this a claim or not a claim? We're here to discuss, this whole purpose of this application is to determine, was the order to strike out it, or was the judge's office correct? If it was not correct, then does that make the order void? And does that now allow her to go back to the Supreme Court to bring her case and set it out for the court to see? I am not in a position today to give you 100% every single thing that would be claimed in that fashion. I can tell you what I know that have transpired. We can listen to the recordings and you can hear how it transpired. You can also see through the information and the emails I provided to you where she was not given an opportunity to get justice. There's a number of things that you can have before you that can show you that there is something there. But is it now for me to argue her case here? Or is it for me to be given leave?
The problem is this. If you are right that the decision below is a nullity, then it will highly likely to simply have to go back for somebody to make a decision. But you may not be right. And if you can conceive of that possibility, if you are not right, we have to deal with the appeal, which on this hypothesis is an appeal against a decision by a person who was a judge from the striking out on the grounds of the thing was frivolous and vexatious. Now, on that hypothesis, in order to try and see whether there is anything in your client's case or anything that survives the limitation period, it is necessary to have some idea, which is the whole purpose of my present questions, as to what her case really is.
Yes. Well, I did set out above some positions in relation to the limitation, and strike out based on limitations in my paragraph 24.
Well, I know, and it's quite right that the court will only strike out on a limitation basis if it's plain that there's nothing that will be capable of getting round the limitation period.
Right.
But if one moves to that question, when is it said that the acts and omissions, which have so far not been adequately particularized, caused the injury complained of?
Or when was she when was she, because remember, his knowledge of injury complained
No,
of,
no,
she
let's
had-
take it in stages. That's a defense
Yes.
to the
Okay.
limitation.
Well, that's correct, my lord. But this would have taken place. We're talking about the application. She'd made an application for access, a custody, care, and control of the child. Okay.
Mhm.
She would have made the application. Let's go back to the top timeline. In 2013. Okay. Seeking the court's assistance to getting at custody of her child. So if we take it from 2013, okay, we are well within the time period for her to bring her action when she brought it. And even if...
But just a moment. You're quite right that she applied on the 10th of September 2013, alleging that there had been a breach of the access order because her son had been denied Skype access to her, and she was then told that she must appear in person or by counsel.
Correct.
But are you telling me that she has no claim in relation to any injury that she may have suffered prior to September 2013?
Well, my lord, her claim has to be looked like I understand it's hard to say in its totality, but it is a knock-on effect. It's almost like this is not a cut and dry instance. We have to look at the instances that would have led up to her demise or the demise of her damage that she would have suffered. No, we would have to look at the whole thing in order for us to give credence to it. Because if we cut and stop and say, okay, no, everything that happened in 2008, that can't be a part of this. Everything that happened in 2009, that can't be a part of this. Even what happened from the beginning can't be a part of it. It has to be that I've been trying, she's been involved with the court for years, makes this application and then gets shut down completely and completely shuts down at that point. And
well,
no
that's
longer.
your problem. That's your problem. Because if, as is the way in which the case has been put before, and appears to be the way in which it's put in the latest medical report, if the case is that her trauma began in 2008, the limitation period has prima facie had long expired before she initiated the proceedings.
But my lord, her limitation would arise only after. I mean, the point about the limitation is only damaging if we don't give credence to her failures or the court's failures in 2013. So what effect of her not being able to... No, but my lord, the effect of her not being to make the application compound would have been the boiling point for her, as it says in the report. Having gone to look at the file, having seen the misfeasance, having gone through all of that, and then she goes and makes this application and denied it, she's suffering. And then she gets assessed later to say if this suffering had been transpiring for a while, but she couldn't identify it. Nobody could identify it. It's a mental illness. This is not something that you're that you have a cut and you know when you got cut. It's not the same. This is something that is totally different when it comes to the person's continence or what they're dealing with or how they're dealing with the anguish.
When is it said that she knew that she had a mental illness?
We have to look at the report, my lord. I do believe we have a copy of it in the mix.
Where is
The
it?
reason that I'm asking these questions is partly to help, because it's necessary to understand that there are, on any view, very grave difficulties in this claim.
I do agree. I understand that, my lord, but
But
she went.
in order to get anywhere near dealing with them, it's necessary to address, as opposed to sidestep, the basic questions that I am asking. Sorry, you want us to look at the report?
Yes.
And where is
my
that?
lord, I do believe Mr. Coelho has a report on his.
Yes. It's on the cloud.
It's on the cloud. And this report is dated the 13th of July, 2020.
Yes, it is.
And so it was, once she had been, I know that my client, not being able to put her finger on what was happening with her, had this report completed to be assessed. She needed to have some understanding. And this is what the report has come to say.
It's the last document on the cloud, so far as the justices are concerned.
Yes, I believe. I do have it open.
Yes, so do I.
Pedro report. Yes, there are some subsequent documents, but I think I found it.
Well, let's go to paragraph 8.1, which is the opinion and conclusions.
Yes. Of this doctor.
The author of the report
She says, based on the clinical interview and assessment using relevant psychometric measures, there is evidence that Ms. Pedro has been experiencing extensive and sustained complex psychological trauma, originally arising from the removal of her son from the care of 2008. Okay. The effects of the psychological trauma have been wide-ranging and pervasive, manifesting as personality change and presence of symptoms of anxiety and depression, anger, intrusive experiences, and attachment difficulties. This has affected Ms. Pedro's emotional and mental state, as well as her relationships with her children and overall well-being and stability of her family. It is evident that Ms. Pedro experienced the removal of Michael Jr. from her care as a profound, debilitating, extremely painful loss from a review of her history and report by Susan Adamar, who had seen Ms. Pedro for bereavement counseling following the death of her mother. It is apparent that she had previously demonstrated extreme resilience and the capacity to recover from...
Well, just pausing there. If one looks with 8.1 and 8.2,
Yes.
it looks as if what is being said is that the trauma began in 2008.
But she's saying from that is where the trauma would have derived from. Just the loss of her son, period. But the loss of her son finalized in 2013, my lord. It wasn't, because remember, in 2008, he wasn't completely taken from her. There was subsequent applications thereafter where she's fighting for him to come back into her custody. Straight through. All the way until 2013 when she was denied the application. So if we can't say that only 2008 is valid, we have to say that straight through she's fighting all the way through until she stopped, until she was no longer allowed.
If you look at paragraph 8.11.
Yes, my lord.
The doctor says, in conclusion, my professional opinion is that Ms. Pedro has endured a range of traumatic experiences, commencing in 2008, but repeated and renewed by subsequent events, which has led to the manifestation of symptoms consistent with a traumatic stress response.
Correct. And recognizes literature and complex trauma. Both of y'all.
So looking at it in the most favorable manner so far as she is concerned, it looks as if she in fact suffered injury from 2008 onwards as a result of the removal of her son, but that may have been affected or increased by subsequent events.
Exasperated.
Yeah, well, now that gives rise to a number of difficult problems, doesn't it? Because subject to any defenses to the limitation period, any injury that she suffered more than 6 years before the commencement of the proceedings would not be recoverable.
But definitely, my lord, there is something to be recovered from the period of time that we take it where the limitation would be covered. I mean, when you say not recoverable, it's still evidence. No, but my lord, but would it not be evidence in addition to? It is supportive of. So if we cut off and say, well, that is irrelevant, right? Then it's almost like you can make an application for you to get leave, for you to bring your applications if it's valid enough. The court, it's up to the judge to determine whether or not they think that it's sufficient or there is sufficient argument to negate the limitation and allow it to proceed. And so we're examining, I understand we're examining that at the moment, but I think it is so important or so significant that should be considered by a justice and for them to make a determination on whether or not.
Well, what we're considering is whether it is sufficiently, what we are considering is whether the facts, insofar as it's asserted, insofar as it's possible to work out what they are, does in fact make it sensible for the judge to consider the evidence. And you keep on referring to 2013, the last unsuccessful attempt to apply, but you're not in fact saying, as I understand it, though at one stage you appeared to be, that her injuries only began in 2013.
I can't say that her injuries. Well, I can't say that her injuries began in 2013, my lord. No. I can't say that. I can't. That's why
so 2013 doesn't represent the commencement of any relevant limitation period.
Well, it does in so far as it can assist as far as her no longer having the opportunity to bring her case.
Yes,
it's almost like the end of her hopelessness. Do you understand what I mean? So
it would be. I follow what you mean. It would be potentially relevant in relation to any increased trauma.
Correct, because now I have no way of getting my child. I'm now completely, what they call hamstrung.
Yeah, but all that is on the basis that the clerk who said she had to appear in person was guilty of misfeasance in a public office.
Well, she's been directed by an agent to advise the imposition. So what position?
Who's that?
Well, she says in the beginning of the email, she was told by the magistrate.
Okay, right. So she acts on behalf of the magistrate who is immune.
Who would have done something. But again, my lord, when there is there misfeasance in office, we would have to have evidence of what that is. Then are we saying that when there's any misfeasance of office, that no claim can be brought to bring remedy to what has happened? And
not against somebody who is immune.
Well, not him in his personal capacity, my lord, but his actual office itself.
Yeah. That's what I'm saying. That.
I know, because it says personal.
Have you got any authority for that proposition? That although the judge is immune, the state can be sued?
I don't have authority at my fingertip for that, my lord. But I would say that in any other instance, or in instances of when you have been aggrieved, you do have a right to bring an action against any particular organ of the state.
No, you don't. The mere fact you have, no, you don't. The mere fact that, and it's an illusion to think that you do, the mere fact that you have been aggrieved does not entitle you necessarily to a remedy. You must know that.
No, I know that, my lord. What I'm saying is that when you have been aggrieved, there are certain instances when you can bring certain actions against the court. And in these circumstances, she is making out a particular case for what she has suffered. I understand the personal liability position. I totally understand the position in relation to of those offices. But if we're speaking of misfeasance, then we have to look at all of the instances that would amount to it, right? to determine whether or not, but is it now for us to do that here though? Should
Well,
we not?
yes, it is in a sense,
Okay,
because if it said that the statement of claim discloses no cause of action, it's necessary to see whether it does.
but it
And that
hasn't.
involves the
You
basic
don't.
questions as to the cause of action, who did or didn't do what, when it happened.
Oh, my
You
lord,
can't
we don't
start
have a
proceedings and
writ.
throw everything and hope for the best.
No, we're not doing that, my lord. We don't have a proper writ before the court to make that determination. We didn't have that in the Supreme Court. We
Didn't
don't
have
even
what?
have. We don't have a writ to examine
you
in
do.
the right
You do.
manner. Hold on,
What
my
do you mean
lord.
you don't have a writ? There was
No,
a
no.
writ.
We do have a writ. Listen to what I'm saying, my lord. We do not have the written way that it's in now, and the form that is in right now is not comprehensible for the court to determine. And so she should be given the opportunity to amend her writ, to bring her action, and allow her to put her case. If it's invalid, or if the court takes a position at that point that the case is a non-starter, then that's the position the court takes. But she should be allowed to do so. She should be allowed to amend what she has to put her case properly, because she hasn't pleaded it properly. There has to be some point where the court says, well, in an interest of justice, in the interest of the rule of law, we should allow Ms. Pedro to now amend her claim and present it in the best light that she can, in order for us to determine whether or not it's going to be able to succeed or not succeed. And she hasn't been given that opportunity at this juncture yet, my lord.
Yes, even if that were so, Ms. Smithby, you do have the obligation to show us, to satisfy us,
Absolutely,
that there
my lord.
is an arguable cause of action.
Absolutely, my lord.
Could you point out the evidence upon which you rely in relation to the 10th of September 2013 decision? What exactly is it you say constituted the misfeasance?
Well, the decision, she wasn't given access to the court. The 2013 application,
Yes,
correct?
where's the communication upon which you rely?
The communication is in paragraph 9 of my skeleton submissions, dated the 17th of September 2013. Good morning, Ms. Pedro. The magistrate has reviewed our application. It was supposed to be her application. In order for the court to proceed with your application, you must confirm that you will be either retaining counsel to act on your behalf and have them file documentation to confirm the same, or confirm that you will appear in person on the date of the hearing. Until such time, the court cannot entertain this matter.
That's said to have been sent on the 17th of September 2013.
That's correct, my
Can
lord.
you help us? You say at paragraph 9, the appellant made a further application to the court, alleging that the then minor child was being abused by the father, and that he complained to be denied access via Skype. So what actually was the application?
It was for her to get access. Custody, care, and control of the child based on the breach. And it was an allegation that he had been abusing the child. She is now making the allegation. It was an allegation that the child was being abused, and the child actually had given a position about the abuse. And so she was seeking the court's assistance to gain access, a custody of him back after a few months after him being in the care of his father this time.
It would have helped if you had included that fact in your skeleton.
Straight 10A states that he can.
Yes, because the dates in paragraph 9 don't make sense either sequentially. Because you say on the 10th she made a further application. It was not until the 25th of September that she had sent a complaint to DCFS.
Mm-hmm.
So where's all of that correspondence on which you rely?
My lord, I didn't put every single evidence in this, because my whole position about this case was to just show that there is some instances or some evidence that would have been able to see, or you can see, that can support a claim that she can make, that her claim. I didn't put the email from the complaint with DCFS, but it was made. Let me just double check. It was an email to Canetta, Ms. Robinson. I'm going to give you the date. One moment while I load it. On the 25th of 2013. I can read the email to you, but you don't have a copy of it, so I don't know if you want to hear it by me reading it out.
Well, this is what I would describe as your new cause of action, because hitherto the understanding was that your client had discovered that she had a cause of action only after return to Bermuda and having inspected the files, the court files.
And I know this was the position that was taken previously.
And that was to have been your response to the limitation defense. So this is really a very new allegation.
Once I went through the information, my lord, I was doing my job. I was trying to determine what would be the starting point for, or what could be the starting point for the limitation, because it's all in interpretation of what had transpired. And if I say, if my position is that that we can count from the last time she would have made her application to the court, then it would put her within the limitation period. But if the court wasn't with me, I then would have had information to support the position down below that there should be consideration given to all of the instances that she would have had, and that forms part of her. Because when she found knowledge of her illness, actually what her illness was, in subsequent reports by the doctor, although she had been suffering, right, the nail in the coffin would have come in 2013.
Can you just look at paragraph 10 of your submission?
And the appellant was prohibited from making the application for breach of access order to further pursue allegations of breach and a minor child against the father, and the appellant.
Yes, that's fine. But rather curiously, you talk about an application for breach of the access order. And again, you don't say that the application was for custody, care, and control.
Because on the application is for custody, care, and control. I don't have a copy of the application to provide, but on the application was custody, care, and control for the minor child. And she had always been, every one of her applications have been for that. Even from the beginning.
Sorry, how do you know that was the application if you haven't got a copy of it?
No, I mean, I don't have it here.
Oh, I see.
I don't have it here. But the appellant made a further application in August of 2017, and she started making applications to the Human Rights Commission thereafter. And that's when she started making her applications to the court to say that she wants to bring action, and tries to found on her footing to deal with this. And when she went to the legal aid department to try and seek assistance, and the difficulty that she faced when trying to get legal aid, even though she would have been a candidate, a good candidate to be granted the legal aid.
Why was her certificate said to have been cancelled?
Well, Mr. Richardson had canceled her certificate, saying that she was a vexatious litigant before she wasn't even given an opportunity. I also put his position in there, and only because I had also been on the board, before I was even involved in this case, did I know the type of fear, I don't want to say fury, but just the type of negate that was happening, and as it relates to Ms. Pedro and her matters. But then she made a subsequent application, and that was granted on merit. And then she was given the opportunity. But then again, she had difficulties with the attorneys who were appointed to her to bring her application. Hence why she ended up doing it by herself. Because she was trying to come to bring this application well before she actually filed her writ in the Supreme Court, but was just finding it extremely difficult to get assistance as a litigant.
Right.
Before you come to what you describe as the culminating moment, that is the refusal on the 10th of September to entertain her matter. The previous orders, number of them are expressive having been made with your client's consent. And at times when she was represented.
Now, the one particular order, she's only consented to one order. Well, the way in which the consent was given was given in a threat, in a sense, because it was the child had been, and I have the recording from the proceedings for us to listen to. The child had been placed in in Maui for about 10 days because of suicidal thoughts and expressions that he was going through after he had been taken away from his mother and just all of the trauma of everything that was happening. So he was put in Maui for 10 days. And the court is saying to Ms. Pedro, either you agree or this is going to happen. The child is going to be put in foster care. So what is she to do under the circumstances? Should she allow her child to have gone in the system, which we all know? I work within these courts when it comes to family matters. It's not a good place for a child to be. Or does she say, my back is up against the wall and the best place, I have no other choice but to say, okay, he can go and stay with his father for right now. But then she then makes a subsequent application for her to have custody of him again. And in the application, her attorney is saying, we are making an application for the child to go with the mother. And the judge is here saying, that's not going to happen. That's not going to happen.
I seek some clarification, my lords. Is counsel saying that the consent reflected on the orders was obtained by duress?
That's what it says in my submissions.
Say that again.
He said, asked if the consent was obtained by duress. And in the beginning of my submissions, I say that consent order that happened on that particular day was done under duress.
Which day is that?
It is on the 8th. Let me just make sure.
Do you mean the 8th of January?
The 8th of January.
2010.
Let's see. 8th of January, 2010.
Because there are 3 orders expressed to be by consent. One is on the 29th of October, 2009. One's on the 3rd of November, and one's on the 8th of January.
The 8th of January was the order that was where the child was placed in the custody, was given not temporary custody, not interim custody, but placed into the care of the father.
Yes.
Because throughout the other applications, it was an interim position. Remember, when the child had been removed from her care from the beginning, he then was placed in the care of the father. And her subsequent applications were to gain back access to him. Because remember, the allegation had never even been made out. There had been no evidence of her abusing the child brought in any of the proceedings. But yet the position was that the child should remain with the father from the beginning, or not from the beginning, in this particular case.
Well, the 8th of January gave joint custody to the parties.
With carrying control to the...
Yes, but there's a difference.
Father. There's a difference.
Yes. Sorry, could you take your hand away from your mouth? It's rather difficult to...
Oh, I'm sorry.
Yeah.
Sorry,
That's okay.
Lord. Sorry.
Right.
But then
So
subsequent applications, my lord, were made for her to have custody again of the child. So this is as I say, the appellant was devastated and shell-shocked by a 2-year battle. That's when she decided to move to the UK and became a bit despondent in relation to this, but still made applications subsequently, because now she's being told by the court that she'll never get her. I mean, that this is the order. And then she's making subsequent applications in order for her to get the child. Up to the 2000.
Well, just a moment. This is very puzzling. You say in your summary that there was, in September 2011, there was an application for access
Breach of access. Yes, yes.
Well, which it makes a difference. In paragraph 6, you say in September 2011, the appellant filed an application for breach and requested the court to grant her access to the minor child via Skype.
That's correct.
Now, that's an application for access, not for care and control.
I appreciate that, my lord.
Right. And then
then,
the application was heard in November. Well, what was the result of it?
They would have indicated the child, this was when the child would have been able to give his,
Yes.
and they would have said that he should have Skype access to her, right?
Right.
And then a further application was then made from the UK by her on the 16th of January 2012 for care and control of the minor child, and
On
to
what
have
date?
access to him
What
for the
did you say?
summertime
I'm sorry, what date was that?
on the 16th of January 2012 for care and
That's
control.
paragraph 7.
7.
And then there was a consent order on the 20th of April.
And
for
the
Michael to
actual,
visit.
and just to note, that actual custody, there was no hearing in relation to should she have care and control. It was just making order for her to have access to him for June, July, and August, and she just
Yeah.
agreed. Now, it was supposed to be adjourned to a further date, but she just agreed, okay, summer, you're going to come to me July and August. But that's when he got into the accident. Then she got into an accident thereafter. Right? And he only was able to come for a month, and she had broken her bone, her styloid bone, and couldn't eat, couldn't do anything. And that's when she further fell into, she just was not in a capacity to do anything because of her accident.
Yeah.
And then on the 10th of September 2013, now she's anticipating that she would be able to pick this back up. And that's when we move into the application when she comes in the 10th of September 2013. And that's when we get the response on the 17th of September 2013 from the court.
Is it possible to summarize in a matter of a few sentences what your case is as to why the Limitation Act doesn't apply?
My lord, I say in my position, my position is that that the limitation should be seen to begin when she was barred from bringing her action for custody. And it would apply to mean that from 2013, the injuries that she may have been suffering from 2008 were exasperated or even realized from the time she was completely barred from seeking justice from the court to at least get custody of her child. And so that is when I say the limitation period should begin to run. And that is why I say that the limitation period doesn't apply under these circumstances, because she would have been well in her time period to bring her action when she brought it. Even though she started trying to bring her action in 2017. But she actually brought it in 2018, still in time.
Now, on that footing, the only injury in relation to which she could claim damages
would be from the report, right?
Say again?
Would it not be from what the report indicates? Hopelessness and...
No, I follow all that. Do let me finish the question before you answer a different one.
Okay.
On that footing, that the limitation period begins in 2013, when there was the culminating moment of her attempt to obtain custody of her child. If the limitation period begins then, that is must be upon the footing that the trauma for which she is claiming is to be taken as beginning in 2013.
And she suffered trauma from then. She suffered trauma.
I can't hear.
I know. I said, my lord, she would have been still suffering all the way through until she would have all the way up until she was assessed in 2020. She's still suffering today.
Yeah, okay, but I want to make sure that you understand why I'm asking these questions.
Yeah, because you're saying, are you, just so I can be clear, my lord, you're saying that if we take it from 2013, any injury that she would have, or anything that she would have endured in 2008 would not apply to 2013.
Yes.
And what I'm saying in relation to that is that is all a part of the matrix of instances that should be considered when we're looking at her damages and what she suffered, because one is knocked on to the other. And I do appreciate your position about it when for the limitation, but when you look at the information and how we're going to assess the pain, suffering, whatever she had endured, right? That is also relevant. What she had endured prior to what she continued to endure moving forward. And it's just as impactful.
It doesn't work. Personal injury claims do not work that way.
I understand, but as far it is for the court to consider, my lord.
Well, I am considering it.
I do
if what I am told is that the cause of action only arose in 2013, that means that no claim is made in relation to a cause of action that arose between 2008 and 2013. That would mean that you could not claim damages for trauma suffered between 2008 and 2013, but you could claim damages for the exacerbation of trauma which began in 2013. Do you follow?
Yes, I do, my lord. I'm just taking the argument a bit further, and I know that the law is what you've stated. The law is that there is no claim that can be made that is outside of the limitation period, but an application can be made to the court to extend the period if it is a basis, if there's a basis for that. And all I'm suggesting is that looking at the issues in its totality, such an application could be made. And so, yes, I take the first point that it is true. There is nothing past that point. But you could also then, based on the Limitation Act, says that you can make these applications and utilize these informations in order to bolster, or not bolster, but to just bring in totality what the particular pain and suffering that would have had to been endured.
That, if I may respectfully say so, I perfectly understand, but it is a different point.
Yes, it is.
I can see that you could proceed upon the basis that you are claiming in respect of any injury that has been suffered from 2008 onwards, recognizing that in relation to a large portion of that period, the claim is prima facie Limitation Act barred, but seeking an extension under the Limitation Act. I do follow that, but that is, when I ask you what your case is on limitation, simply to bestow the period starts from 2013 is in fact not the whole of your case. What you have just said is different, that there is a claim in relation to 2008 and onwards, but that is based upon a claim for an extension under the relevant section of the Act. Is that right?
Correct.
Now, in that regard, I think you must address what had happened before 2013, and in particular, I bring your attention again to the order of the 8th of January 2010, the first paragraph, where it says that Ms. Wanda Peters states that in the interest and welfare of Michael Jones Jr., that she wishes to withdraw her application for custody, care, and control of Michael, and in this regard, the court orders that her application is hereby withdrawn. And she was represented then, as she had been before. How then do you frame your argument for misfeasance in relation to any time before the 10th of September 2013?
When she would have used those words on the date of the 2008 application, my lord, the proceeding had been a very lengthy hearing. And this was in light of Mr. Hurst's child have been in Maui. And the court took the position that if there was no agreement, because she was very adamant about her getting access, custody, care, and control of the child, the father was very adamant about getting custody, care, and control of the child. It was a very, very tumultuous back and forth thing. The court said, well, we're going to put the child in foster care if there's no agreement. So in her mind at the time, she thought it was best for her to step back. Maybe she should not have done that. She did it based on just emotions or whatnot, but it was her thinking that instead of letting my child go to foster care, I'll let him stay with his dad, having known that I may have another day in court, or I may be able to seek a further order for me to get access or a custody of this child, even though but then to subsequently not be given that opportunity, and it never happened thereafter, is when you see everything go downhill. And so she says it was under duress because it was under the threat that he was going to be put in foster care. This foster care is a very serious thing for a mother to say, oh, now I'm going to put my child with strangers. So what is she to do? I understand that when you consent to orders, that you are acceding to the order, that is an order. That's just like an order of the court. I absolutely appreciate that position. And it's just like the court would have made an order, and you look at what the parties' positions were. But we're looking at an order that was made under, and she says under duress, based on the threat of her child being put in foster care. That's a very serious duress.
That's not duress, Miss Bean. That's she taking the appellant taking a realistic view of the likely scenarios that might occur. That's not duress. She went in, as you rightly said a moment ago, knowing what might happen if she didn't agree to the order. But that's not duress. That's just a realistic appreciation of the circumstances.
My lady, I do appreciate your position. I think she would say, in alternative to that was nothing short of a threat and duress for her, because she had been pushing straight through that she wanted her child back. Her whole application was that what was being said about her was a lie, that it never happened, and he should have never been taken from her care in the first place. And then the applications turned into a complete circus of who's mentally capacitated and who's not mentally capacitated, and who is having issues and who's not having issues. And then the child was put in Maui for 10 days for being suicidal. So this is all happening right before a hearing that she goes to court. The child, it's being very clearly stated that the child was in Maui then, previously for 10 days. And so I hear you in relation to her being, oh, well, maybe the best thing for her to do is step aside. But no, the only thing that she could have done to save her child, this is for her to save her child now. Now she's fighting to get her child back, and she's not getting anywhere. The court is very clearly saying to her, I'm not giving you this child back. And then she knows that it was in light of no proof. Zero information has ever been brought to the court's attention that she actually even put a hand on this child. Not once.
Excuse me.
Well, that's not quite true. The report that we've seen, the social inquiry report, or whatever it's called, does in fact contain allegations of abuse. That's
from the father, but never came with a conclusion. It says it's allegations, not conclusion that she was abusing him.
Well,
and
no,
that was
only.
Evidence. I understand that, my lord, but that also, the report has to be considered on both ends, no? And then backed up.
Yes, but you can't say there's no evidence just because you don't like it.
No, I appreciate that, my lord, but it was again based on what the father said. So in these cases, when we have family court cases, right, and we have DCFS come with a report, the report is usually what this person says and what that person says, and then it comes with a recommendation thereafter, and the court then has to make a decision based on the evidence that came, right? And all of the information that she provided, and I do appreciate that, sometimes you don't get what you want, but all the information provided and even the substantiation, there wasn't even an additional circumstantial piece of evidence that supports
Well,
that he was
anyway,
abusive.
you say, as I understand it, tell me if I misunderstood it, that the fact that the judge said that he wasn't going to give her custody, and there was that he might put the child in foster care, constitutes duress.
But the
Means
child will be. He
Okay,
said he will be placed in
constitutes
foster care.
duress means that the consent order is not truly a consent order. And I think you say means that the magistrate was guilty of misfeasance. Do you?
Essentially, my lord, this is what Miss Pedro
The
is
answer is
saying.
yes. Right.
Yes, that's what Miss Pedro is saying.
Right. Well, I can see that. But
Will you accept, Ms. Bean, that unfortunate though the consequences may have been for your client, assuming that there is some merit to allegation of trauma, psychological trauma, the obligation of the court was to do what was in the best interest of the child.
Yes, my lord.
You accept that?
Yes, my lord. That is the overriding principle.
Ms. Smith Bean, incidentally, your client has written to me in a group chat saying that she'd like to have a moment with you to give instructions.
May we step out, my lord, if that's possible?
yes. We'll go to a breakout room, and your client can give you instructions.
Thank you, my lord.
Okay,
If
all
that
the
can be
breakout
arranged.
rooms are open, so you can retire to the appellant's room as well as the judges to the judge's room.
You do have to put those two into a breakout room?
They have a breakout room.
Okay, you have? Okay, good.
Good day, Quilo. I'm back.
Okay, I was just sending a message to let you all know that we are going to start at 11:25.
So 5 minutes?
No, not 5 minutes. I have 11:22, so 3 minutes. All right, the proceedings are reconvened.
Good day, my lords. Before we adjourned for a few minutes, there was a point about that my lord Justice Smelling was suggesting in relation to the best interest of the child. We have to remember that during this application that was being heard before the magistrate, there was a application or a submission made on behalf of the minor child by the attorney representing Ms. Pedro at the time, Ms. Narinda Assange. She made the application for the child, for Ms. Pedro to have custody and care and control of the child. Why? The child, when he had been placed in Maui for the 10-day period, was making allegations against his father, having given ideations of suicide while he was in the care. And she's given this information based on what had been reported from the child while he had been at Maui. And she says to the judge, please, your worship, we're making this application based on the fact that the child has been suffering, based on the fact that the child has reported these things, based on the fact that in light of the information that would have come from the school counselor during that hearing as well, that the child has met a very, very decreasing demise since being in the care of the father, and has said and stated that he wishes to be home with his mother. He wishes to be back with mommy and visiting daddy. And this is all of the information that was before the court, given under the circumstances. And then the judge says, that's not going to happen. The child is provided they have details. And I think it's better that we listen to the actual proceedings so you can actually hear how it all transpired. And could that be considered in the best interest of the child in light of all of the positions that was being given by the attorney, by the school counselor, and also what was reported from him being in Maui? Was it the next step for us to say, well, no, that's not going to happen. The child's not going back to the mother. The child should remain in the father's care, even though he has been suicidal, even though his continence, his abilities have all diminished since being out of his mother care. And even though she's making such an application to save this child from all of the things he had been suffering from, then he should still remain in the custody of his father. So none of that, all of that information was present during the hearing. And in light of that, the fact as well.
By the hearing, Ms. Smith, now you're referring to the hearing on the 8th of January 2010?
Yes, my lord. This is during that hearing. And this is while my client had custody of her 12-year-old daughter, who she had been caring for straight through. So if no application was ever made that she was an abusive person to the child, they kept her in her custody. She was able to raise that child, and the child was able to move on and everything. But now she's trying to raise her son or obtain custody of her child. And she sees that he's suffering, and he's saying that he wants to take his life because because of what he's been experiencing at home with his father. He's in Maui. So this is all of the things that she's dealing with while she's presenting herself to the court to try and fix these problems. And the school counselor comes to say, Michael's a different child. Michael has been saying he wants to go back to his mother. Michael has been saying this. Michael has been saying that. And Michael has been a totally different child since he's not been in the care of his mother. And Maui comes to report the situation, and they still say, not gonna happen. It's not gonna happen. The magistrate is not gonna happen. She's not gonna get back this child. And so when we look at the welfare principle, what do we look at? What is the considerations? The considerations have to be what is happening to the child and what is the best for that child and what the child may have been enduring at the time. And based on the evidence that was actually before the court, and you can hear in the recordings, my lord, that I provided to the court, what had transpired during that hearing, the evidence was very clear that the child had been suffering. The child was suicidal, all in the attempts to saying, I just want to be back home with my mother. This is a child who had been with the mother straight through prior to when the allegation was made that she had done anything, which was unsubstantiated later. Always in the care of the mother. This is not a situation where they were married. This is a situation where she had this child out of wedlock, and the child was then taken away from her based on a lie. And she's going through this process of trying to gain custody back of her child. And all we have is every turn she's been rejected based on this lie. So think of the mental anguish she may have been even dealing with, even in those stages, hearing her child's going to take his life. And people are coming to say, no, the child's been suffering. He should go back to the mother. And the court's still saying, that's not good enough for me. She gets no play here. It's not going to happen. That's exactly how we said it. It's not going to happen. That's not going to happen.
So you are firmly and squarely asserting that the misfeasance was at the hands of the magistrate.
Magistrate. And there was also I just have to clarify in relation to her thought process when going through and when we were speaking about when she went to go and read the file, because a lot of other information would have been arisen or come to her attention at that particular point. Even the email from there's an email from DCFS that was saying that she probably would have done something to the child, and that's why we should be moving forward. But no, like it was all of these things culminated. And when the affidavit of the DCFS agent was there to give it, she leaves out all of the things that she puts privately to other persons back and forth that are in the file. And she's seeing how careless and callous there had been taken the position of these proceedings and what they were suggesting in their emails. And so she's reading all of this and absolutely even further feeling despair, and that they were all in some type of collusion to keep this child away from her, lacking all the evidence that should be around for these cases. This is not a case where there has been repeated abuse, or there was something issue here and then an issue there, and then the court finally makes a decision. No, this is the father saying one thing. They then taking the child away from her immediately without any investigation, and never, ever, ever, ever returning the child to her care, ever. And no such evidence besides the report from the DCFS that said that this was the allegation to substantiate taking this child away from this mother. And that's what we're saying is sufficient. We're saying that that's enough. That's enough to say that she is an abusive mother. That's enough for her to say she should never get this child back. That's enough for her to say that she should accept the orders. That's enough for her to consent to give her child away. That's enough. And that's just how that cookie crumbles, because that's just litigation. It can't be the case. That cannot be the case. I don't think that the intent is to just by default, or that's just the way in which the case had been presented, and we should accede to, okay, well, we must agree with that's what the judge had to consider, and obviously in the best interest of the child, even though he had all this other information at his disposal, even though the child had been suicidal because he left his mother, it was enough for him to say no, he should still remain in the care of his father, suicidal, or suffer going to foster care, because we're not giving him to his mother. We're not giving him to his mother.
Yes, you've said that several times now. I think
I know,
we got
because
it the first time.
I'm sorry, my lord.
We got it the first time. If you say it 3 times, we don't get any improvement from it.
No, I understand that, my lord. I'm saying it to because my client is the one who's aggrieved here. I'm only trying to represent her feelings, or not feelings,
Yes.
but her
Well, what we're looking for you for is
there was sufficient evidence during the hearing that proved otherwise, that was ignored. I'll say that.
Right, well, sorry, let's just see where you've got to. You say that there was misfeasance by the magistrate in making the order in 2010. That's right, is it?
Correct.
Yes. And where have we got to in relation to misfeasance? And you say there was misfeasance by the clerk on the instructions of the magistrate in saying that she had to appear by counsel or in person.
And I think your next point would be, where's the misfeasance of the DCFS team?
Yes.
And the misfeasance of the DCFS team is that they never carried out any investigation on Ms. Pedro. They done no investigation whatsoever in relation to the abuse. All they did was write a report that said that her father said that he abused the child. They didn't even have any positions from the child saying that the mother abused the child. They didn't have any reports from anybody else saying that there was an abusive relationship between the child and the mother. They didn't even go as far as going to any of the peripheral persons who they could have spoken to get determinations on whether there was an abuse of the child. And that is, to my client, it's criminal, she says.
Yes. Well, and then in relation to limitation, you say that she could, on any view, recover the excessive trauma after she was refused the ability to appear in 2001.
13?
And in relation to events from 2008 onwards, what is the escape from the limitation period?
She would be given the opportunity to make the application to the court to say that the limitation could be set aside, or that the limitation would be considered. She could make that application to the court, what we discussed earlier, asking for the limitation to be set aside based on the information therein of what she had suffered or what she had endured, that it would be sufficient enough for the court to say, yes, we're going to set aside the limitation and allow you to bring your claim.
Yes. Now, the basis upon which the registrar / acting judge decided against you was that one, possibly the most material question under the Act, was the extent to which the plaintiff acted promptly and reasonably once she knew whether or not the act of admission of the defendant to which the was attributable might be capable at that time of giving rise to an action for damages. And I think what was said was she discovered all the stuff about the DCFS personnel when she looked at the records, and she did that in, I think, 2016, and could have done it before. And the proceedings weren't started until 2018.
And I believe her position in relation to why she didn't do it before was because she just couldn't, she literally could not bring herself to go back to what she had been dealing with this whole time, didn't know how to address it, and finally built up enough courage to go and read it, and then discovers all these additional things that just put her in the position to say, now I need to bring this claim.
And when did she do that?
I'm saying this was when she read the file. We're saying,
yes, when?
But
which date?
I believe it was a 2017 date, my lord, was when she read the file. You just stated it.
Sorry?
I believe you just stated that it was in 2017 when she went.
Well, I said it was either in 2016 or 2017.
Let
It
me
seems
get
to be
the
different.
specific date. Let me get the specific date.
Various dates have been given, my lord, if I can
It's-
assist.
Yes,
She's-
various dates have been given. That's why I asked for the real date.
She said 2017, my lord, 2017. That was when she read it, 2017.
That
When
has
in
been
2000?
said for the first time now, but in the lower court, it was asserted that that happened in 2016.
And I do note that she does seek the legal aid certificate in 2017 when she's seeking the assistance of Alexandra Wheatley when she wrote directly to Miss Wheatley about her case and spoke to her directly when she was in the legal aid department.
Well, if you go to the transcript of the hearing,
Which one, my lord? Which?
well, that's another irritation. I'm actually looking at the transcript of the hearing in the record of appeal. You attach to your submissions a transcript, which is the same, except it has different pagination.
Well, it would have been, I didn't have access to the actual transcript from the record of appeal after Mr. Hill would have taken possession, but Ms. Pedro would have provided me with a transcript that was almost, now you say is the exact same, for me to have an idea of what had transpired in the court below. And so it goes through the, what
Well,
was said.
Can you look at the record of appeal? Tab 13.
Can I beg your indulgence 1 second, my lord? I need to pull it up on the electronic portal.
Paragraph 26.
Paragraph, sorry.
Oh,
Paginated in our
sorry, I was
file.
looking at the judgment where
Yes, but
Oh, for some reason, I have one file now. Hold on, let me just see something.
I think it's up to point out while counsel looks that there has been no agreed transcript of the proceedings.
Truth.
What is before the court and has been presented by Ms. Pedro reflects handwritten notes by her during the hearing. There has never been an attempt to transcribe the audio recording formally and to file it in court.
well, wait a moment.
Well, that's not.
Just a moment. What I am looking at tab 13 of the record of appeal is headed Transcript of Hearing of the 24th of September, prepared by the plaintiff from an audio recording from Courtsmart.
That's exactly where it came from, my lord. From the actual audio recording from Courtsmart, because we don't. That's where she got it from.
That hasn't been agreed, my lord, because I certainly have not been privy to that at all.
I know
Well-
we would have asked since then that the court provide the full recording for us to have access to it, for us to listen as to what actually happened in the court below.
Well,
So that
never mind this squabble for the moment. If you go to page 20,
I'm still trying to find the actual document
that's-
where you're speaking of, my lord. I'm on the portal, but it's very difficult to follow this document. So I'm looking for
Right.
something that's labeled. What is it labeled, my lord?
informal transcript of hearing of 24th September.
Okay. Informal. Okay. Have that now. I'm opening it. What paragraph were you referring to, my lord? Sorry.
Well, the paragraphs are not paginated, as
Okay,
they wouldn't
no.
be with the transcript. But if you go to page 20,
I don't know how I know which page is 20, but I'll keep going.
well, the bottom of my screen, it's got a thing where you can move the pages. Have you got that?
I collected the file in 2016.
Yeah. Have you got there, Ms. Smith?
I am now on. Is it the page that says yes? It is particularly D and E. Is at the top.
No.
Is it the next? Okay, pause for a second. There, share. My number on when I'm looking on this, it doesn't give me a number. So I'm just trying to find out what's the first thing on the top of the page that you're
First
That
thing
looking
on
is
the top of
what
the
you
page.
stated
Yeah.
at the top of that page.
at. Say it
The
again.
words, that is what you stated. You stated you had lawyers.
Ms. Smith Bean, are you viewing the PDF in the web browser of the cloud?
That's correct. That says informal transcript of hearing of the 24th of September
If you hover
2019.
your mouse at the top, a bar will appear that tells you the page number.
It's not doing that for me on my Mac. I have it now. That is what you stated. You stated you
Yes,
and
now
had
go-
lawyers.
Go
Okay.
down a bit. You will see that your client says,
Well, I
to
collected the
the-
file in 2016 when I came back from my father's funeral. She says, I got the file in 2016. When I got back from my father's funeral on October 2016, I did not read it until March of 2017.
So where do you get that from?
This is what she's telling me.
Oh,
This is what she's saying to me, my Lord. I could only, this is what she's saying to me. I'm just clarifying what's the position.
Well, you'll see that is all discussed in the middle of the page that we are on the transcript. She does say 2016.
Then she collected it. I collected the file in 2016. It doesn't say when she read it. It just says she collected it then. But she's saying now she actually read it in March of 2017.
but that's over a year before the proceedings were instituted.
And I don't know what month it was in 2016. When did her father pass away?
December, I think.
December. So
Wrong.
this would have been at the end of 2016. And then in March of 2017 is when she says she read it. And then you can see she's making applications to legal aid thereafter.
I
Her
may be
first,
wrong about December.
oh, was it? I can ask her, when was that your father passed away, Miss Pedro? She can tell me just now. Give me 1 second, my Lord.
What may be worse, further on in the transcript, at what would be page 28, in a long response to the court, she does say, when I read the file in 2017, I only actually discovered that what they were doing was wrong. It's a long passage on page 28.
In the same document that we're in, my Lord? Okay, so under section 3 act and under section I do know she's also trying to expound to Miss Alexander Wheatley that of also some positions of a breach of the articles of the Constitution that she also had tried to set out in her claim that she had been suffered from as well. And she's saying, Mrs. Wheatley is saying in one of the paragraphs, trying to go through with her what she could pull out of the submissions or what Miss Pedro had set out in her various documents as to what her position was.
And how would you articulate that constitutional claim?
Well, it is the Article 6 point, my lord, about the breach of the, not being able to access justice, so or the not having a fair and an unencumbered right to a fair hearing, and that Article 6 breach, and that could be formulated through a number of instances that she endured while she was going through this process in support of that application. But I see that I pointed it out because it was something that she made clear to the court at the time. And I note that when they were going through the exercise of going through her information, I would have thought that it would have been included at that point that she needed to amend her appeal, amend her submissions, or given the opportunity to amend her submissions so that she should be clear as to what she was claiming, because she's acting in person. We are reviewing the actions of a litigant in person, not a person who was represented by any counsel whatsoever. So I know we see a lot of irregularities. I know we see a lot of mix-up because she's a person acting in person. And in my submissions, I do.
Well, which lack of a fair hearing are you talking about?
Well,
and the last three important ones, she was represented by counsel.
The one that there was one that she wasn't allowed to bring the application at all.
Yes, I follow that.
Yes. So, my lord, that is a part of all of this. And so we're talking about what are her claims. So I'm just looking at it on a broad spectrum of what was being reviewed by the court below as to what information was available. And I still say that if in all of the what you would think would be jumble, I guess, and all of the unclearness, some clarity could have been done by the court, or some position could have been taken by the court at that time that, miss, you need to go and find a lawyer to help you properly bring this to court, because right now it's not in a position for us to really adjudicate on. And that was, I think Mr. Moodie even brought that up and said, I think we need to go back and she might need an opportunity to really do this properly. But she didn't get that. What does Ms. Wheatley say? No, we're going to continue. We're moving on. We're going on now. We're dealing with it now. And this is what we have in front of us, and this is what we're going by.
Here you are talking about the proceedings before the acting judge.
This is the why, yes, my lord. Because we're talking about this transcripts that we're reviewing right now is actually the striking out application with the acting judge. And she definitely was a litigant in person during this action. So, I mean, should she be given opportunity? Should she not be given the opportunity? That really boils down to, should she be given the opportunity to bring her case in the Supreme Court? Or does the Court of Appeal now say, no, you shouldn't have that opportunity to properly plead your case and come back to court?
You would accept that opportunity would only have been necessitated if there was a tenable cause of action, one that could have been properly pleaded in the first place, a reasonable cause of action.
My lord, and I will say that if given the opportunity, she should be allowed to present a reasonable cause of action. I can't say, based on the pleadings that were before the court, that it was pleaded in the right manner. So I understand us looking at to see if you're saying, oh, now based on what we've looked at, we don't see a cause of action. But I say that based on what we've looked at, I do see a cause of action. And I do think that she should be allowed to properly plead it. And that should be given, she be allowed to do that. This is what justice is all about. People come to court and sometimes they're right, sometimes they're wrong, but they should be given their day. They should be given the opportunity to prove whether they're right or wrong. By taking it away from her completely because of her inability to properly put it in the right context, I think that that's not what justice is about. This is not the, this is, it doesn't follow the rules of natural justice. I can, that's my position.
Just before we leave limitation, in front of the judge, it was, I think, argued that this was a case of fraudulent concealment. Is that not the case?
I think that I can't say that I'm going to be. Miss Pedro said fraudulent concealment of information. I don't say that to say that that was what it amounts to. It may amount to something else.
Right.
I wouldn't say that it amounts to fraudulent concealment. This is the words that she put again. My Lord,
Right. Okay.
we're looking at somebody who don't know law.
Yes, yeah, that's fine. But we who are lawyers can put out of our minds fraudulent concealment for these purposes.
Absolutely, but I'm just saying.
Yes, good. Well, that's fine. I just wanted to make clear, understand where we are.
Yes.
Right. Now, is there anything else that you would like to submit?
I think I've said what I
Right.
think should happen under the circumstances, my Lord.
Well, thank you very much. It's the most convenient moment. We will now adjourn until the afternoon session.
Yes, my Lord. What time would you like to start, my Lord?
Well, might we be able, I'm not subject to my colleague's view, might we be able to resume in 45 minutes? Would that be okay?
I'm in the court time, my Lord.
Well, I'm
Fine by me. It's fine by me.
Fine by me as well.
And convenient for council as well.
Right. Well, we'll resume in 45 minutes, whatever that is at the time of where you are located.
Yes.
Thank you.
Yes, my Lord.
Please mute your mics. Don't leave the call. Just mute your mics and stop your videos.
I see we're not quite ready, Mr. Moodie. See you later.
Certainly, my lord.
Good afternoon, my lord.
Good afternoon. I see you're not quite ready, so see you later.
Mr. Quaylo,
Yes, Ms. Smith-Bean.
I've sent an email to you in relation to one case and an article that I'd like the Court of Appeal to take a look at in
Okay.
relation to what we're talking about. The case itself is a very, very old case. So I'm trying to get actually a copy of the judgment, but all I've been able to find is the judgment on a website rather than the actual document itself.
Right.
But it sets out a particular position I want to put to the court. So I'm trying to figure out what would be the best way to show the judgment, having regard to the fact that it's not the actual case itself. It's like the full judgment, but still not the full
This is just
document.
an abstract.
Right. So this is just an abstract. So this is the case of Ashby and White. It's a very, very old case, 1700s. You might be able to get it.
Well, I was
The
going to
citation?
say, do you have a proper citation?
I do. It's 1703,
1703.
number 92,
Uh-huh.
ER
Yeah.
126.
126.
You
All
might
right.
be able to find it.
I will get back to you, but we can go ahead and reconvene while I'm looking for that.
Okay.
Okay. Is Justice Smelly on this call?
He was just a minute ago. So yes, I did see him.
Yes, I am.
Okay. Great. All right. So if all parties are here, we can pick up.
That's it.
I think it was the respondent.
Yes, my lord. Just before my learned friend starts, I sent an article, and the clerk has advised that he may be able to find the actual excerpt for the case. But there's a case that deals with misfeasance of public office, and it deals with the position of how that should be dealt with, and it's from a 1700. It's called Ashby and White, and so I just want to draw the court's attention to that case when we look at the misfeasance point of public office and how it's dealt with and what damages could flow from it and all of that. It's a 1703 case called Ashby and White, and then there's an article that I've sent to the Court of Appeal that speaks about diminishing the judges' just blanket. The word is escaping me.
Immunity.
Immunity, and this thought now of diminishing that immunity in the UK, and I've provided an article about that. One more point, sorry, my lord. I just wanted to be clear that Mr. Moodie had made mention earlier about the transcript that we were looking through being the transcript created by my client, but she received the recording from Brian Mello. And that's where the transcript information came from Brian Mello. So it wasn't her creating it on her, just her making it up on herself. It was derived from what was received from Mr. Mello.
Who made the transcript? Who made the transcript?
She typed it, I believe, but it was from the exact recording that she got from Mr. Mello.
Right. I'm sorry, I was muted before and didn't realize I was. What you've sent, have you sent the reference to the case?
I don't know why my computer keeps going on mute, but I do have the reference I can type into everyone just now. I just provided it to the Court of Appeal, to the clerk. The reference for the case is 1703, number 92 ER126. ER126. I'm just going to type it in just for clarity.
Would you be so kind as to send me a copy as well, counsel? I haven't received a copy of the email.
I can send you where I have the judgment, a copy of the page where I have the judgment. I've gotten it off of another website, but the actual case itself, I was just trying to get a copy of it, but it's so old that the actual PDF of it is eluding me at the moment. I've done a lot of searching during the break to try and get it.
These cases which have ER, English reports in them, are in fact often in another range of reports, because a series of reports were all gathered together to make the English reports. But some of those cases are in fact on Bailey, which I don't think has the English reports. Do you have any other reference than 92 ER126?
I've been able to retrieve it, so I'll upload it to the cloud now.
Oh, thank you.
Perfect.
And what proposition do you rely on it for?
And this was in relation to the misfeasance point of public office.
Confirming that it can be tortious.
Correct. That's what the case says, and that damages can flow from it. I can read the excerpt that I would have just discovered. This is a bit long, but the main part of it is that it says that, and I am of the opinion, and it was an action where one of, I think it'd be what you could consider a lord was not able to take a vote. And the Justice Lord Holt, and then it was apparently assented to by the House of Lords by a vote of 15 to 16. But his dissent was upheld by the House of Lords, by a vote of 15 to 16. His judgment reads as follows. Then I am of the opinion that this action on the case is a proper action. My brother Powell indeed thinks that an action upon the case is not maintainable because here is no hurt or damage to the plaintiff, but surely every injury imports a damage, though it does not cost the party one farthing, and it is impossible to prove the contrary, for a damage is not merely pecuniary, but an injury imports a damage. And when a man is thereby hindered of his right, as in an action for slanderous words, though a man does not lose a penny by reason of speaking them, yet he shall have an action. So if a man gives another a cut off cuff on the ear, though it cost him nothing, no, not so much as a little dechelon, yet he shall have his action, for it is a personal injury. So a man shall have an action against another for riding over his ground, though it do him no damage, for it is an invasion of his property, and the other who has no right to come there. And in these cases, the action is brought via et armis. But for invasion of another's franchise, trespass via et armis does not lie, but an action of trespass on the case, as where a man has returnum bravum, he shall have an action against any one who enters and invades his franchise, though he lose nothing by it. So here in the principal case, the plaintiff is obstructed of his right and shall therefore have his action. And it is no objection to say that it will occasion multiplicity of actions. For if a man will multiply injuries, actions must be multiplied too. For every man that is injured ought to have his recompense.
Right.
For the benefit of the court, the English report is now on the cloud as Ashby and White, 1 English report 417.
It doesn't seem to have got onto my cloud. Grello.
You may have to hit the refresh button.
Oh, I see. Oh, God. Sorry, which is the refresh button?
The circular arrow at the top by your web address.
Thank you, Graylo. If you also put in the search bar, my lord, Ashby, it'll come up as a search within the files that are therein.
Oh, yes, it has appeared. Yes, well, we'll have to look at that, but it seems to be a case against some council official returning officer for not allowing somebody to vote when he was entitled to do so. Not quite sure where that takes us.
It actually supports the misfeasance of public office and saying that you do have damages when you that occur in these instances. And I know that it as far as the judiciary is concerned, I still know that we have the bar of the immunity, but that's why I brought the article in play as well. But it just says that, you know, it's just given the position, what the court's position was about you being able to bring an action against public office. I just found it because I was looking for the point.
Sorry, what court's position?
No, the misfeasance. What do you mean, which court's position, sir?
Well, you said that there's an article which talks about the court's position.
No,
I don't understand what.
The article about the immunity of judges when there is when we spoke about earlier about the judge having immunity and actions being brought against them. I just added an article that's speaking of how they wish to diminish that immunity in the UK. We're looking at, and as a talking point, my lord. I added it in to the email that I sent to Quelo.
I mean, does the article say the immunity doesn't exist? That it ought to be changed?
It says that it ought to be changed. It should be diminished. It says it ought to be changed, my lord. It says that it should be brought down to more of a different level, not to the highest heights of you just cannot have no case against you whatsoever, is what the article is saying.
The article is in what?
I emailed it to the Court of
Appeal. What is it in? Just tell us.
When you say what is it in?
It's an article. Is it in a magazine? Is it in a book?
It's published in the Cambridge University Press.
Right.
Of Legal Studies.
Right.
That's where it was published, cambridge.org.
Yes, well, we'll certainly look at it. I fear that we are bound by what the law is rather than what Cambridge academics think it ought to be, that being a matter which their lordships sitting in the Privy Council will have to determine.
Yes, my lord. But I do know I mean, this court has a very wide jurisdiction to determine certain positions. So I take that point. I just brought it to your attention.
Not to change the law of England.
I understand.
Bermuda.
I understand.
Right. Okay. Thank you very much. Yes. Moodie.
Good afternoon, my lords and my lady. We have heard quite a lot this morning, some of which certainly I would submit is outside of any of the grounds being relied on for this appeal. We have heard some new concepts in relation to consent and consent by duress, and some different aspects, which I will address as best as I can going forward. Subject to you, I think it would perhaps be most useful for me to try and address the de facto doctrine first, as counsel had addressed that first. I do make one notation, and I think the observation was echoed by the court, in that the very extensive submissions offered by Mr. Hill when he represented the appellant, going through the hierarchy of rules and the normative rules, was certainly misconceived as it relates to the issues in this appeal. This is not a case where we're looking at the applicability of the Supreme Court Act vis-a-vis the Constitution. This is merely a case where the issue is, how do we interpret the constitutional provision at hand? It is our position for the respondent that the judgment is valid, notwithstanding any apparent or possible defect in the appointment of the judge, and that the court should uphold the striking out of the claim on several grounds. We say, my lords, that the courts have long recognized the utility and purpose of upholding judicial acts and decisions, notwithstanding technical defects in the appointment of the person purporting to exercise that judicial authority. That is what has been referred to as the de facto doctrine. And to follow along in paragraph 3 of my skeleton arguments, it operates to validate the acts of an official who operates under the color of law, even though it is later discovered that there were deficiencies in the appointment process. This doctrine finds its rationale in public policy and operates to ensure that the system of public justice remains intact. And this wasn't addressed by my friend at all. She proffered, on behalf of her client, a strictly literal interpretation of the constitutional provision. And there was no attempt to get into what was the intent of the provision. The doctrine relies on the presumption by all parties concerned that the judicial officer was properly appointed, and it ensures the continued orderly function of the government and justice system despite the technical defects in the appointment. Your lordships very helpfully traversed the Margaret Peer case, which encapsulated the principle. And so I won't trouble you with going through that case again, but I certainly would like to draw your attention to two other cases where the doctrine has been discussed. The first case I would like to refer to is the case of DPP. It's at tab 5, sorry, tab. Yes, this is the DPP against William Penn from the Court of Appeal of the BVI. It is at tab 4 of the bundle entitled Skeleton Arguments, which was filed by me.
Yes.
That was a case concerning the Jury Act in the BVI. And the essence of the issue before the court was a default by the returning officer who omitted to perform his statutory duties over a long period of time to maintain a register from which the array of jurors would be impaneled. Starting at paragraph 15 of the board's decision in that case. The question in the present case, whether when default by the returning officer is revealed after trial, the consequences either automatically or in the circumstances of this case, that a venire de novo should be issued and a retrial ordered. At paragraph 16, the court looked at the case of Montreal Street Railway Company against Normandy and said, the Montreal case involved, like the present case, very elaborate and minute statutory enactments. Municipalities were to provide annual lists of qualified persons, which a board on which the sheriff sat and which he apparently chaired was to revise and make a list of grand jurors. That did not happen. And at paragraph 17, the judgment of the board was quoted, the judgment which was delivered by Sir Arthur Channell was quoted by the board. And I think, as noted in that case, it is also worth repeating here because it is relevant. That quotation, the statutes contain no enactment as to what is to be the consequence of non-observance of these provisions. It is contended for the appellants that the consequence is that the trial was coram non judice and must be treated as a nullity. It is necessary to consider the principles which have been adopted in construing statutes of this character and the authorities, so far as there are any, on the particular question arising here. The question whether provisions in a statute are directory or imperative have frequently arisen in this country, but it has been said that no general rule can be laid down, and that in every case, the object of the statute must be looked at. One line down, when the provisions of a statute relate to the performance of a public duty, and the case is such that to hold null and void acts done in neglect of this duty would work serious general inconvenience or injustice to persons who have no control over those entrusted with the duty, and at the same time would not promote the main object of the legislature, it has been the practice to hold such provisions to be directory only, the neglect of them, though punishable, not affecting the validity of the acts done. This principle has been applied to, and the board notes, the Margaret Peer case, to justices acting without having taken the prescribed oath. And the quotation continues after the reference to the Margaret Peer case. In the case now before the board, it would cause the greatest public inconvenience if it were held that neglect to observe the provisions of the statute made the verdicts of all juries taken from the lists ipso facto null and void, so that no jury trials could be held until a duly revised list had been prepared. Paragraph 18. The board correctly, and I think the court recognized this earlier today, that the modern tendency is no longer to seek to identify or distinguish between mandatory and directory acts. But the board's judgment in the Montreal Street Railway case underlines the need for careful examination of the relevant legislation to ascertain the purpose of the statutory proceedings and whether an intention should be attributed to the legislature that non-compliance with such procedures should render a jury trial a nullity, irrespective of whether it may have occasioned potential unfairness or prejudice. We say those considerations apply in the instant case, and I think the court averted to them today when it raised questions for the appellant in terms of, well, what happens if the judge heard other divorces? What happens to the orders made in those cases? And we say those are indeed relevant considerations for the court to consider in determining whether or not the de facto doctrine should be applied. The other thing that...
Interrupt you for a moment. I follow exactly what you're saying. But as I think the cases have indicated, there are a number of different possibilities as to what the de facto doctrine covers. I mean, you can have a number of different circumstances. Let's assume that the person whose appointment is in issue is called X. You can have a situation where X has never been appointed at all. One of the examples given by Lord Justice Alan Ward in one of the cases is the usher who decides that he'll take part in the proceedings. That's one possibility. Another possibility is that X was believed by the governor and by him to have been appointed, but in fact, through some administrative foul-up, the governor forgot to sign and never did sign the instrument of appointment. The next possibility down the scale is that X was appointed but never took any oath. The next down the scale is that X was appointed but took the wrong oath. There may be others.
Certainly, I agree with you, Lord.
I mean, it may be that, I mean, there's some discussion in the cases as to quite how far the de facto doctrine goes, though there's a passage in Wade that says that it may extend to somebody who was never validly appointed at all. But in that respect, it might be going quite a long way forward to say that somebody who was never validly appointed at all, nonetheless, his acts were valid, when the Constitution says that in order to act, he has to be appointed by the governor.
As in the case of the Allahabad case, which certainly can be distinguished from the instant facts. And I address this in paragraph 4 of my submissions, the question you have now posed, where I say a review of the case law will show that for the de facto doctrine to be given effect, 3 prerequisites must be established. A, the decision maker should actually be in possession of the office and be performing the duties attached to it. B, there should be some apparent right to the office and acquiescence by the public that the person occupies the office. And C, the acts in question must be for the benefit of third parties, not for the office holder's own interest.
Yeah.
I also note that in construing the statutory provisions, in DPP against Penn, the board notes that when it comes to criminal proceedings, the court is much more careful in assessing the statutory provision, and will much less readily depart from the literal interpretation, so to speak, depending on the consequences. But certainly we say that based on the provision itself in Section 75 of the Bermuda Constitution, it would appear that Miss Wheatley was appointed by the instrument that was signed by the governor. And that is a different situation than exists in the Allahabad High Court. That was a criminal proceeding, and the provision itself is different, which requires the taking of the oath before the appointment materializes.
Yes. Well, I see the way in which you put it in paragraph 4, that the decision maker should actually be in possession of the office.
Yes.
And you may be right about that, at least so far as anything under the Constitution is concerned. But bundle, or skeleton argument bundle at tab 2, you will find the case of forgery and Murfitt. And if you go to paragraph 18, the English Court of Appeal referred to a passage in Wade, which reads as follows: the acts of an officer or judge may be held to be valid in law, even though his own appointment is invalid, and in truth, he has no legal power at all. Now, if that, I mean, that's an academic textbook, doesn't necessarily represent the law. But I mean, if that was the extent of the de facto doctrine, it would be difficult to fit with the Constitution.
It certainly would be, because it is very far-reaching. And I think the board recognized that and made a distinction in the DPP against Penn case. It refers in paragraph 22 to the forgery case, where it says, and I am about 6 lines from the bottom of paragraph 22.
Yes.
In forgery and in Copard, the court said that a decision by someone aware that he had no power to reach it would fall into a different category and be a nullity. So that alludes back to one of the criteria that I set out in paragraph 4 of my submissions, my lord, that the decision maker should be in possession of the office. They must actually think they are clothed with that colorable authority. And as you can see from the affidavit of Miss Wheatley, it certainly was her opinion that she was properly appointed, and no issue was raised by the parties at that time as to her appointment. If you need, I can refer you to her affidavit specifically.
No. But yes, I mean, what they say at paragraph 22 of Penn is that in forgery and in Copard, the court said that a decision by someone aware that he had no power to reach it would fall into a different category. But you can have a situation in which a party is not aware that he has no power to reach the decision. Take my second example of the man or woman who is glad to see from the Gazette that he's been appointed as an acting judge, and has every reason to believe that the governor has signed the instrument of appointment, not least because he went and swore an oath in front of the governor. But if the governor had in fact not signed the appointment, unless one can say that in those circumstances he was deemed to have assented to the appointment otherwise, but if the governor has not in fact assented, the judge, the quote judge, close quotes in question, would not be aware that he wasn't a judge, but in fact he wouldn't be.
True, and that is why I would submit that I don't know that forgery or the decision in forgery would be followed to the extent that it certainly implies today, given other cases and the reflections of the board.
Yes. Well, I don't know. It might be followed in a non-constitutional case,
Certainly,
but we're not concerned with that.
certainly. To continue very briefly, paragraph 23 of DPP and Penn.
Yes.
The qualification recognized in the de facto cases that the de facto judge must act in good faith and be believed by himself and all concerned to be acting with authority matches the qualification regarding impersonation identified in the jury cases which the board has discussed previously. The de facto cases, one line down, reflect an approach which can be said to be broadly consistent with and may even be regarded as going further than that taken in jury cases. And to that extent, I would say that the forgery case might fall within those cases. The other case I would wish to briefly draw your attention to is merely to illustrate the application and applicability of the de facto doctrine in the Commonwealth Caribbean. And that is the case of Paul Chen Young against Ajax Investments at tab 5 of that bundle. And again, I cite this case only to reference the examples cited therein. And therefore I won't keep you very long on it, but I will start at paragraph 51 of the Paul Chen Young case.
Yeah.
The court was helpfully referred by Mr. Hilton, Queen's Counsel, to 3 cases from the region in order to illustrate the operation of the de facto doctrine. The first in time is Whitfield against the Attorney General, a decision of the Court of Appeal of the Bahamas. The issue arose in that case because it was said that as a result of a deficiency in the process by which the tenure of the office of Chief Justice had been extended beyond the constitutional retirement age of 65, a decision given by him as a member of the election court would be ineffective in law. At first instance, Justice Gonzalez Sabola, as he then was, held that on the basis of the de facto doctrine, any decision given by the election court, of which the Chief Justice was a member, would have been valid despite any irregularities in the manner of extending his tenure of office after his attainment of the age of 65 years. The Court of Appeal affirmed this decision. The court referred to, among others, the decision in State of Connecticut against Carroll, in which it was explained that an officer de facto is one whose acts, though not those of a lawful officer, the law upon principles of policy and justice will hold valid so far as they involve the interests of the public and third persons, where the duties of the office were exercised. Reference was also made to Ree James, Attorney General intervening, in which Lord Denning, Master of the Rolls, observed of such a judge that he sits in the seat of the judge. He wears the robes of a judge. He holds the office of a judge. Maybe he was not validly appointed, but still he holds the office. It is the office that matters, not the incumbent. So long as the man holds the office and exercises it duly and in accordance with law, his orders are not a nullity.
That is typical Lord Denning, but it is in fact, I think, based on an erroneous proposition. He wears the robes of a judge, fine. He holds the office of a judge. Well, why does he? He hasn't been appointed.
Exactly.
What in fact the true position is he purports to hold the office of a judge. Maybe he was not validly appointed, but still he holds the office. Well, not really. Yes,
and so an examination of the exact constitutional stipulation would be relevant there to adopt that. I do take that point. But to continue at paragraph 53, the principle was also applied by the Court of Appeal of Belize in the Queen against Myers. That is a case in which a judge of the Supreme Court continued to sit and presided over a large number of criminal trials, despite the fact that he had attained constitutionally mandated retirement age of 65. It was held in that case that the de facto doctrine applied to protect the validity of the decisions of the judge taken after he had passed the retirement age. After a painstaking review of a number of relevant authorities, Motley concluded as follows. From the cases, it is clear that for the de facto doctrine to apply, the judge must have a colorable title or authority. In addition, the judge must have acted in good faith and must have been believed by himself to have the necessary authority to act and has been treated by litigants as having such authority. The doctrine cannot be invoked by a person who knows he has no authority to sit as a judge, but nonetheless usurps the function of a judge. The rationale for the de facto doctrine is that the logic of annulling the decision of the de facto judge must yield to the need to protect the reputation of the law and the public confidence in it, as well as the interests of the parties who acted on the assumption that the trial was being properly conducted. And lastly, the court, sorry, go ahead.
Well, that's all fine and dandy, but what in fact the court did in this case was to hold that the retired judges who hadn't got an extension, who had reached the statutory age and had retired and had not got an extension from the governor, that their judgment was invalid.
Well, I certainly didn't pick that up from
Well, let's have a look.
It's summarized at the last page in the order.
Yes,
so it in fact in the case that I'm referencing now, the Paul Chen Young case, the de facto doctrine was found not to apply.
Yes.
In this case, so I accept that. So which is why my proviso was I reference it only to cite examples where the court found it applicable. So I'm not suggesting that it was found applicable in the Paul Chen Young case.
It wasn't.
So the very last reference, and I'll end at this paragraph. And lastly, paragraph 54, there's a notable first instance decision of Justice Rahim in the High Court of Trinidad and Tobago in Shirley Sukar against the Attorney General. That was a case in which a judge of the High Court who had resigned his office some 3 years before without having delivered judgment was reappointed for a day for the specific purpose of doing so. The claimant's challenge to the validity of his appointment failed on other grounds, but Rahim also considered that it would have been possible to apply the de facto doctrine. The court then goes on to consider the meaning and effect of the constitutional provision that it was looking at in this case, which was section 106 of the Jamaican Constitution. But the point is, my lord, that if we are to look at the intent and purpose of section 75 of the Bermuda Constitution, we submit that that constitutional requirement is there to secure, to ensure that the public has a right of access to a competent court to determine disputes and for a fair trial in accordance with Article 6 of the Bermuda Constitution. And based on the wording, we would say that any defect in the appointment process ought not to be viewed by this court as inhibiting such access. And that is
Was there such a defect here, Mr. Moodie?
I think that is arguable.
Are you accepting that this judicial officer was merely a de facto judge?
No, I don't accept that there was a defect. I think that is certainly arguable. The facts.
I'm talking about in the appointment, of course.
The facts of this case indicate that Ms. Wheatley swore both the judicial oath and the oath of allegiance when she was appointed as registrar. There is a question open to the court as to whether she swore the oaths in the capacity of acting judge. She says she thinks she did, but certainly without more, the court perhaps will not accept it. But
she can't possibly have done. an acting judge is appointed to act for a specific period. When the registrar was appointed the registrar, she was appointed the registrar, and she must have sworn the oath as registrar. As she wasn't then an acting judge, she couldn't conceivably have sworn the oath of an acting judge, which she wasn't.
Agreed, but I think there is a fine line because
just a moment, I recall that inquiries were made and there is no evidence of an oath as an acting judge having been sworn or ascribed to.
Okay, I just recall that in her affidavit, she said she could not find it. But I do accept the court's indication that inquiries were made. I still think it is a fine line because if she took the oath of office and the judicial oath as a registrar, I think the court has recognized that the only difference to those oaths, to the judicial oath at very least, in terms of as an acting judge, would be the actual term. I swear it as an actual judge. For all intents and purposes, the oath is exactly the same. And based on, there is an assertion made that, or that can be made, that perhaps she should not be forced to swear the same oath more than once. So I do think it is an open question. It's not the same oath. It isn't, but I think materially, for all intents and purposes, it is. And I think that is a relevant factor that this court can consider and should consider.
What is said against you is that if this is right, the obligation to swear an oath to act as an acting judge is in effect without effect, because no sanction arises. And so what the Constitution laid down it has no effect.
I don't think that is an argument that I would agree with, because I think the courts, in their approach to these matters and to looking at the de facto doctrine, have looked at each circumstance differently. They have looked at the particular provision and they have looked at the possible consequences that can occur in the scenario. So perhaps the position would be different if this was the only case. I'm not saying it would be that Miss Wheatley sat on or heard. But I think the circumstances of each individual case has to be judged on its own. So no general proposition can be put forth, I would say. And I would certainly say in this case, where it appears that Miss Wheatley has heard, purportedly in her capacity as acting judge, several other matters, the court must consider the detriment to the public and weigh the balance at the end of the day between the public inconvenience and the desirability of upholding the rule of law and confidence in the court.
Which the Constitution must have had in mind.
Certainly, I certainly think it is a relevant consideration what the intent of the Constitution.
In the Margate Pier case, the court appears to have held that the provision that an oath should be sworn was something that was, I think they used the expression, restraining on the magistrate who could have been criminally prosecuted.
Yes.
But that doesn't arise here.
No, it doesn't. And there is no consequence in the Constitution for what should happen if the oath isn't sworn. And I think this is what leaves it open to the discretion of the court in the circumstances of this case.
Right.
I don't think I can take the de facto doctrine much further unless you have any further questions for me. And therefore, I would seek to address the other submissions, particularly in terms of any irregularities in the pleadings, etc.
Yeah.
The first thing we note, my lords and my lady, is, and I think it is very relevant because even in this morning's session, it appeared as though what indeed the appellant was seeking to do is launch a collateral attack on the orders made by the family court. And I refer specifically to submissions made in relation to the order made in January 2010. This is not an appeal of those orders. In fact, that is part of the deficiency in the appellant's case. Those orders could have been appealed. That is why we say there is no issue even of misfeasance, if there could be misfeasance by the magistrate, because that could have been appealed. And the appellant was represented at that time and had every opportunity to appeal.
Can you appeal an order that's been made by consent?
Well, if you are saying that that consent was obtained by duress, certainly it would require you to object at the earliest opportunity to say, I was under duress. I don't think that it can meet the legal burden to meet duress, as Milady observed. Certainly without more than this bare assertion. And a lot of the assertions being made are bare assertions without more, without any evidence, to be fair. And I think that is also relevant as to what occurred in these hearings and whether indeed there was duress and the method by which the consent was obtained. Certainly on the face of it, prima facie, none of the orders indicate that. Prima facie, the orders indicate that the consent, there was a rationale indicated for the consent, that the appellant consented to withdraw the application in the best interests, etc. And I think those are also relevant considerations. In terms
she
of,
says she did so because the judge said, no, you're not going to have him, and I may put him into care. And faced with that unattractive possibility, she caved in.
Is that duress? I don't think that meets duress. Was there a threat to her person that caused her to cave in? Was she not represented by counsel who could have advised her? Maybe she might have an action against counsel. And I'm not suggesting that she does, but certainly there may have been other remedies open to her. But certainly to an order that you disagree with, you do not allow it to stand. You appeal it as is appropriate, and within the time limited for doing so. The appellants say that it was not obvious that the defendant was taking issue with limitations, and we disagree. We say that the pleadings by themselves disclose that the defendant was taking issue with the entitlement to relief in respect of causes of action, which we say accrued between 2008 and 2010.
Well, wait a minute, that won't do, will it? Your defense says what it says, but the one thing it doesn't say is that we rely on the Limitation Act.
It doesn't use that word limitation, but it certainly was clear, we say, that the position was that given that the orders were made between 2008 and 2010, the plaintiff was entitled to no relief whatsoever. That is the only interpretation we say can come from the pleadings. And if you look at the defense, which appears at tab 8 of the draft record of appeal, we say no other reasonable interpretation can be made. And it is set out at paragraph 6, where I traversed the orders that were made from April 1, 2008 to to November 2009, which were the orders I had in my possession at the time. And we say at paragraph 7, by reason of those orders, the plaintiff is not entitled to any damages or any other relief claimed in the matter. So I do accept that we didn't use the word limitation, but I think if you look at those pleadings, which were followed up by our skeleton submissions where limitation was actually stated, there can be no doubt that that is what we were raising.
Well, I hear what you say, but it's trite law, which, so far as I recall, I learned either at university or in my pupillage, that if you want to rely upon the Limitation Act, you have to plead it. And if you don't do that, then the question doesn't arise. And if I was opening this case for Miss Pedro, I would say to the court, of course, the position is that the Limitation Act has not been pleaded, so we needn't concern ourselves with that.
Well, I did refer the court to the case of Ronex Properties against John Lang Construction, which is one of the supplemental authorities.
Yes, but what that case says is if it is apparent the limitation point is to be taken, why then, in a clear enough case, even if it hasn't been pleaded, there's an application to strike out, the court can strike the case out. But what happened here is that there's nothing in the defense. There's nothing specific in the strikeout application because it refers to the various bases upon which you can strike out. And the word limitation only appears in your skeleton, which a litigant in person received at 8 o'clock the evening before the hearing.
We certainly do admit that there were some administrative deficencies.
That's a delicate way of putting it.
But it's correct, and in fact that is what happens. But we believe that, as Lord Justice Stevenson, Ronex Properties, pointed out, that it was obvious from the application, so far as we had put it, and from the pleadings as I submitted to you earlier, the only reasonable interpretation was that limitation was certainly something that the defendant would be relying on. And one of the reasons we say that the plaintiff at that time was not prejudiced, even by the late filing of the skeleton submissions, is because all of the information which she would have relied on to dispute the applicability of the Limitation Act was already before the court in her pleadings. So, for example, if you look at the record of appeal, her statement of damages for social workers at tab 6. All the allegations of fraud which she makes, and which my friends will argue, she ought to have had an opportunity to give evidence. All of this information was before the court in this which substituted for a statement of claim. At paragraph 4, writing false reports, she alleges fraud there. At paragraph 5, accepting a claim without demanding any form of evidence. And it goes on and on. At paragraph 13, unlawful and unjustified forced removal of her son. At paragraph 14, suppressing an email that was sent. So all of the information in relation to the fraud, which would have been relevant to her disputing the applicability of the Limitation Act, was indeed before the court. And in fact, the irregular manner of the pleadings is what I think inured for me to be able to say that she suffered very little prejudice by not formally giving evidence. This information was there.
Just before we leave it, you relied upon the judgment of Lord Justice Stevenson in Ronex, but I've just looked at the relevant paragraph, sentence, where he says the right course is therefore for a defendant to apply to strike out the plaintiff's claim as frivolous and vexatious and an abuse of the process of the court on the ground that it is statute barred. Then the plaintiff and the court know that the statute of limitation will be pleaded. The defendant can, if necessary, file evidence to that effect. The plaintiff can file evidence in response. So what he was saying is what you can do is take out a summons on those grounds stating that the claim is statute barred. And the fact that it's not then in the pleading is neither here nor there. But he wasn't saying anything other
It
than
isn't
that.
necessary. I do take that, but what I would urge this court to find is that even with that deficiency, there is no prejudice to the defendant, to the appellant in this case, because she in fact has no good answer to the limitation defense point.
Right. What's wrong with her answers?
Well, if we look at how the judge treated them, and I think she did so appropriately. If we look at the ruling of the judge, tab 12 of the draft record of appeal, the judge goes through the positions of the defendant, applicant's position, and the respondent's position, starting at paragraph 19.
Yeah.
Mr. Moodie's submissions on behalf of the defendant were quite straightforward. The defense statement filed on 23rd August clearly sets out the time frame in which the defendant made an application to the magistrate's family court for supervision orders. On the 3 occasions the parties appeared before the court, in 2008 and one in 2009, it was admitted by the plaintiff that she consented to the supervision orders being sought by the defendants.
But it wasn't. I mean, that's what's recorded in the order. But in the course of the hearing, she said she didn't consent to anything.
I do recall there was some point during the course of the hearing where it was put to her. And
Ms. Pedro, can you not gesticulate into the camera? It's very distracting.
And I think that recollection is echoed by paragraph 24 of the judgment, where Ms. Wheatley says, notably, sorry, there's another one. Yes, notably, Ms. Pedro confirmed she did not appeal any of the decisions made in the magistrate's family court, and that she believed she had been, quote, defeated and had no further recourse. Furthermore, Ms. Pedro, throughout the hearing, confirmed she consented to the supervision orders made by DCFS in 2008 and 2009. I do recall, you know, there were different things being said by Ms. Pedro during that hearing. And there certainly was some point where she said she didn't consent. I do recall that. But I also recall her saying she consented at some period.
I'm sorry, my lord. I didn't mean to interrupt my learned friend, but I have to object. Because if you looked at the transcripts of actually what proceeded during the case in the Supreme Court, she said over and over and over that she hadn't consented to any of these positions. And he even took the point that some of the documents that she's referring to maybe should be dealt with before they decide on the strikeout application in his paragraph. And that was his assertion to Ms. Wheatley.
That assertion still remains because those documents still have not been presented. Counsel has referred to applications in 2013 and 2011, which have not been produced. Where are these applications? There are none that is before the court. I see that one ground now being brought forward for the first time is misfeasance through the clerk because she failed to allow Ms. Pedro to bring an application in 2013. There has been no evidence put forward of an attempt to do so. And that is why I've said much of this argument has been based on mere assertions and nothing more. We have not been presented. And I think Mr. Hill, to his credit, when he was representing Ms. Pedro, anticipated that perhaps some sort of Ladd versus Marshall application for new evidence might be necessary, which was never pursued. But certainly none of these documents purporting to show these applications which should disallow the limitation period or should reduce the limitation period have been brought before this court. They're bare assertions and nothing more. So to return to the judgment.
Well, just before we go, and I've got at page 15 of my version of the transcripts, the registrar, Ms. Wheatley is saying, can I just stop you for a second, Ms. Pedro? Did you or did you not consent to these supervision orders being put into place? Answer, no, I didn't. Obviously, I didn't. I was never in the
I do remember that.
Oh.
I do remember that. You know, where I can recall parts of what the transcript says, I certainly will not resile from that. I couldn't do that. So I do not resile from the position that I urged the court to allow for further evidence if it thought necessary. But I do reflect and recognize that much of the evidence, because of the irregularity of pleadings, was already before the court in the form that we are now taking to represent her statement of claim. The evidence of fraud, the evidence that she suggests of conspiracy. And again, these are bare assertions, but they were placed before the court by Miss Pedro from the bringing of her action.
Mm-hmm.
And so that's why I say there was little, if no prejudice in Miss Wheatley's failure to allow sworn evidence. I think the court sought to seek a balance in relation to, you know, she was a litigant in person, and while the court has an obligation, I would say, to assist a litigant in person, I do maintain that there are no special rules for litigants in person, certainly in terms of fundamental rules of procedure, such as the time period in which to appeal, the time period in which you must act. So in the hearing, Ms. Pedro was, you know, allowed to make submissions as to why the limitation period should not apply. And she relied on certain sections of the Limitation Act, which would provide exceptions. And the court, quite rightly, reflected on those submissions and did not accept Ms. Pedro's reliance because, as Ms. Wheatley recognized, she was represented by counsel. There was absolutely no good reason why she should only have had access to the file in 2016. And even though there's a medical report that is being proffered now, there is nothing in that medical report that indicates that Ms. Pedro was under a disability in terms of not being able to appreciate the nature of the proceedings, not being able to appreciate that time ran. And if we take the medical report at its very best, you know, when did Ms. Pedro become aware of her mental condition? Was it in 2008? Was it in 2017 when she just received the report? If she was being treated from 2008 for these issues, she certainly would have known of these issues. And so we say, you know, there's every reason why the limitation period should start to run from 2008, at very least from 2010. Because even the medical report as it is now does not indicate that she was under any sort of disability which would have prevented her from complying with the applicable time periods. It was indicated, I think this morning in the evidence, that Ms. Pedro received the file in 2016, but didn't read it until several months later in 2017. Again, is this a reasonable delay in the circumstances? We say it is not. No good reason has been proffered. No medical evidence has been proffered which would justify any further delay outside of the limitation period. And so we say it should be discounted. And the medical report we submit has very little, if no effect on, or should have very little or no effect on the court's consideration of the limitation period and when it runs from. in essence, I think our position is that Ms. Pedro's claim with respect is entirely without merit when looked at in the round. She had accepted at the initial hearing the position expressed by Ms. Wheatley that magistrates are immune from suit. And I certainly haven't looked at counsel's case yet, but I would still maintain that the state cannot be liable for any of the orders made by the court, which Ms. Pedro is asserting has caused her physical injuries, mental injuries. If you disagree with an order, the procedure is to appeal that order. To say that you have suffered, to not appeal the order and then say you've suffered personal injuries as a result of it is really a collateral attack on that order, a second or third bite at the cherry, as the case may be. And I think that would be manifestly unjust. And that is what Ms. Wheatley considered when she made her determination and weighed the balance as to whether or not limitation should apply in the facts of this case. Finally, my lords, I would just repeat one submission, and that is, without more than the bare allegations of consent by duress, we say that this case is fatally compromised because the orders were, on the face of it, consent orders, and because no appeal has ever been filed in relation to those orders. Whether the court takes a view that in relation to this new ground, which I haven't taken instructions on, I haven't looked at the law on in relation to whether or not whether she can claim for an exacerbation of her mental condition from 2013 onward, I would have to reserve some sort of any opinion on that, because again, it's based on a bare assertion, and I don't see, even with the medical report, any direct relevance and any direct indication of any impediment or disability. What the medical report says is, I think it's plain for all to see. She has suffered a traumatic situation. She suffers from adjustment disorder. There is no indication that her faculties have been impaired by this medical condition. In fact, if we are to take it as is, the medical report says she will continue to suffer until another decision is made, until these acts have been remedied. And certainly that is not something that should be put on the Crown or on the judges who would have carried out their due diligence and their job according to the Children Act and made orders in the best interests of the child, as they did at the time. Unless I can assist you with any more on any aspect.
Well, there are just a few things. It's quite difficult to have in mind all the different ways in which from time to time it's put, but let's just deal with the last one. What is said is that the fact that on the instructions of the magistrate, the clerk told her that she had to appear either in person or by counsel was the last straw in 2013, and that exacerbated her previous mental trauma. Now, it must be, I'm thinking aloud at the moment, but it must be right that if somebody negligently does something which makes your previous condition worse, you are entitled in principle to damages for that. But I suspect you say that the problem is that what is relied upon is an instruction given by the clerk upon the direction of the magistrate, in relation to which the magistrate is immune.
Certainly, my lord, that would be my position. The other thing I would say is the medical report does not support that legal argument that there was an exacerbation in 2013 as a result of that incident.
Well, it's a little vague. It says that she suffered from trauma as a result of a series of recurrent matters, which I don't think it identifies.
At 8.11, in conclusion, my professional opinion is that Ms. Pedro has endured a range of traumatic experiences, commencing in 2008, but repeated and renewed by subsequent events, which has led to the manifestation of symptoms consistent with a traumatic stress response, recognized within the literature as complex trauma. I mean, there are so many bridges to cross here. Is traumatic stress response something out of the ordinary which would give rise to an action for damages? Don't we all undergo traumatic stress response when things don't happen in our favor? And to what extent? I think there's a lot that is unanswered. And I agree that the medical report is particularly vague. And I reference it in relation to, for example, PTSD. PTSD can exist on several different levels, and it is not every level of PTSD which puts one under a disability to respond. I don't know what can be said about this medical report. The medical report that has been submitted, it references previous medical reports which have not been provided. I think there is one referenced that was done by Susan Adamar. I'm looking at the top.
Yes, what he does refer to.
Yes, and a report from Dr. Philip Brownwell. We don't know what these medical reports say. And, for an appellant who must put her case forward, I say the case is wanting, and we submit that the case is wanting by any material which should convince this court that there is indeed a condition which meant she was under some disability, whereby any of the exceptions to the Limitation Act should apply.
Well, wait a minute, let's take it in stages. If the position is that any exacerbation was only caused by that which is not suable for, because it was the decision of the magistrate communicated by the clerk, then a claim on that basis doesn't exist.
Certainly.
You say in addition that there isn't actually any evidence of exacerbation at all.
Exactly. So right. I do argue both grounds.
Yes. Let us go back.
Isn't there also the question of whether or not there are other options, other ranges of responses open to her, other than to respond in a traumatized way?
I'm not sure I quite.
If the instructions from the magistrate were that she needed to have appeared in person, wouldn't that have been an option available to her?
Well, certainly that was available to her. And I think what I got from that email, and let me look at it again, which is referred to in paragraph 9 of counsel's submission. In order for the court to proceed with your application, you must confirm that you will be either retaining counsel to act on your behalf and have them file documentation to confirm the same, or that you will appear in person. So this wasn't saying to her, she must come to Bermuda to do it. This was saying, because of the nature of this matter, you should have counsel file on your behalf. So there were several options given to her.
No, I don't agree. I'm sorry, I have to object there as well.
I'm just reading what it says, and I'm sure
what you're saying, she could appear by Zoom.
Well, she could have appeared by counsel.
Well,
The
that's
whole-
one
Make the
possibility.
application.
But counsel costs money. Could she appear by Zoom?
It doesn't say that.
Do not interrupt, please.
It does not say that, but certainly I don't think the court got into any issue about counsel and money. And my experience with the family court is that it does not get into those issues. Representational issues are not dealt with by the family court in terms of remuneration of even the court-appointed counsel. Those are not issues that the family court gets into. It's beyond their jurisdiction. The issue of affordability is either dealt with by an application under the Legal Aid Act, and there is an issue as to whether or not family matters and children's matters can fall under the Legal Aid Act. But those are private issues that are not inquired into by the court.
Okay. Now let's go back in time. Forget about any exacerbation that might have occurred in 2013 of existing trauma. Look at the position from 2008 onwards. You say that everything between the limitation period in relation to what happened.
Certainly the final order in 2010, yes.
The final order was in 2010. And it's really up to then that the magistrate is supposed to have behaved badly, and the people from the Children and Family Services Department. So that will take one to 2016, and the proceedings were not issued until 2018.
Certainly, and there has been no, I would say, reasonable explanation proffered, notwithstanding the medical report, for that delay. Ms. Wheatley rejected the explanation. Quite rightly, I submit.
Where did she do that?
In paragraph 27, where she says it was not accepted that the time frame would commence when Miss Pedro says she viewed the files. The court reflected there, Miss Wheatley reflected there, that she chose not to obtain the file until 2016, and thereafter she did not bring the proceedings until 2 years later. It was not accepted the time frame would therefore commence from 2016.
Yes, this is a slight confusion, because if the position was that the period, the limitation period prima facie expired 6 years after 2010, then the next question is not when any time frame commenced, but whether or not the court should exercise its jurisdiction under section 34 to disapply the time limit that has already expired. Isn't that right?
Yes, that is, I'm trying to pull up section 34 as we are now. Discretion to exclude time limit in case of personal
injury. Actually set out in the judgment.
Yes. And the point I make there is, what did Miss Wheatley have before her? An assertion that there was sorry, I've lost the Zoom. An assertion that there was a mental injury. There was no medical report. This medical report wasn't obtained until July of this year. So there was absolutely nothing before Miss Wheatley at the time to indicate when she knew of her, notwithstanding what I say are deficiencies in the medical report, when she knew of that mental injury. I think there are two different exceptions which Ms. Pedro tried to invoke, one of which isn't relevant now because it relates to deceit and fraud by concealment. which council has abandoned.
Yeah.
And the other one would be the exception under Section 34 of the Limitation Act. Discretion to exclude it in terms of personal injury or death. And the court at that time, under that provision, shall have regard, and I'm looking at 34(3), shall have regard to all the circumstances of the case, and in particular, the length of and the reasons for the delay on the part of the plaintiff. There was nothing before the court there to say, to speak to this mental health issue as a reason, and certainly we would have objected and made the same observation we're making now about the fact that it does not indicate that she was under any disability. And I think in particular, if I look at 34(3)(e), which the judge underlined, the extent to which the plaintiff acted promptly and reasonably once he knew whether or not the act or omission of the defendant to which the injury was attributable might be capable at a time of giving rise to an action for damages. I think it is fair to say that there was nothing said by Miss Pedro that convinced Miss Wheatley that she acted promptly and reasonably, specifically having regard to the fact that she was represented by counsel. In fact, in the hearing, I don't know if it appears in the transcript, but Miss Pedro complained about counsel. And my response, I don't know if it was caught on the transcript or just sotto voce, was, well, you may have an action against counsel, but that is not a reason to disapply the limitation period, and certainly not based on any of the assertions made by Miss Pedro.
Yes, what the judge decided is at paragraph 29, the claim has been made out of time. I do not accept Miss Pedro's reliance in sections 33 and 34. Well, 33 is concealment, 34, which is abandoned, as they don't apply to the facts of this case. I do not accept she made any attempt to act promptly or reasonably to bring forward
this claim.
And then she says, her statement of claim relies on the alleged damages being done over the last 10 years, which means any injury and or pain and suffering she is seeking damages for did not commence or only become known to her when she reviewed the court files in 2016.
And I think the medical report submitted supports that conclusion by the judge.
But that would appear to show that she was asserting that there was an injury from 2008 onwards, effectively.
Yeah, it would. And in paragraph 31, Ms. Wheatley continues, Ms. Pedro has not raised any valid argument why she can escape the reliance of the defendant on her claim being time barred in accordance with the act.
Yes.
And in the final line, the plaintiff did not appeal the decisions made in the magistrate's family court or make any reasonable effort to bring this matter before the court in a timely manner, despite all the applications put before the magistrate's court being consented to by her. And we now know what she says about that consent. But I think the judge quite properly put her mind to the explanation proffered, and quite rightly, based on the facts as alleged, or the submissions of Ms. Pedro, rejected them as not complying with the exception provisions in section 34.
Now, the last matter is this. If you go back to the judgment at paragraph 15, the learned judge sets out the provisions of the Limitation Act as to time limits. And in subsection 4, she sets out, except where section 51 applies, The period applicable is 6 years from the date on which the cause of action accrued.
Accrued says subsection 5, except where subsection 5 applies.
Yes. The period applicable is 6 years from the date on which the cause of action accrued, or the date of knowledge if later of the person injured, whichever is the later. And there is in fact, although the learned judge doesn't set it out, an extensive definition of the date of knowledge in section 15.
Definition of date of knowledge under sections 12 and 13.
Yes.
In sections 12 and 13, references to a person's date of knowledge are references to the date on which she first had knowledge of the following facts: that the injury in question was significant, that the injury was attributable in whole or part to the act or omission, which is alleged to constitute negligence, nuisance, or breach of duty. This is another aspect. These exceptions only apply in relation to causes of action, negligence, nuisance, or breach of duty. I see the attempt to bring in misfeasance in public office, which, you know, I think arguably can fall under breach of duty. But I still don't think it makes a difference. This section makes a difference to any submission that Ms. Pedro made and the facts as the judge found them to be. Again, remember, the judge did not have any medical report before her. So could she have opined on whether or not the injury in question was significant, whether the injury was attributable in part or in whole to any omission or breach of duty? No, she couldn't. None of these things were put before the judge. So she was entitled to conclude as she did. And even if it was put before the judge, you know, as I've indicated now, we would have taken issue with it. And I think a part of what this court must consider is, you know, whether, even if this case is returned to the Supreme Court, can it survive another application to strike out based on these same assertions? I submit it cannot.
Right. Right, thank you. Well, those are my questions. I don't know whether any of my colleagues have any.
I don't think so, thank you.
Thank you.
Thank you to the court and to counsel.
Ms. Smith-Bean, is there anything you wish to say in reply?
Yes, my lord. First, I must address the last point in relation to the breach of duty. I think my learned friend has gotten too far. We've gone too far as the application that was made firstly before the court for the strikeout, because within the transcripts, right, a number of representations or positions were asserted by my learned friend of the lack of information that was before the court, and a lot of assertions that my client would have made during the time. And then I say that it was at that point that the proceedings should have stopped and the application should have been made where she should have been given the opportunity to properly plead her case. That not having been done, all of the deficiencies that may have arisen throughout the pleadings that could have been remedied by making such an application or being through amended has not happened. And so now my learned friend is being able to rely on all of the deficiencies that were laid bare to the Supreme Court below based on the lack of information that was before the court. Now he says that my client is making some bare assertions. We have the recording from the proceedings in 2000 on the 8th of January for us to hear. We can all hear exactly what took place during that hearing. You can hear every one of the responses that she gave and how in which the order was then dealt with. My client then goes through a process of application after application before the court, subsequent to that application, and then finds it important to her to then go back to her case, but when she goes back to the court to seek some assistance, was not given that opportunity to do so. A number of instances come arise from that, right? When she is approached to the court to say that she wishes to deal with that issue, there is the breach of her constitutional right. Now, I understand my learned friend's position that, oh, it doesn't say that she didn't have access to the court, but it does. Because prior to her going to the court on those occasions, she had had hearing after hearing where she was remotely accepted by the court to participate in the hearing. It was until she comes to this application are they now telling her that she has to appear in person.
Well, does it?
It says in person. It says that, my lord. It says either you get a lawyer, which she may not have been able to afford. That does not allow abstract her from coming to court, or you come in person. And she's in the UK at this point, having had already participated in cases, in this case, remotely.
Could she not obtain legal aid at this stage?
But my lord, she was denied legal aid. And then only when she made the application for her to make this application that's before the court, that was before the Supreme Court, was she given only legal aid to get an opinion. So there were applications for her to have an attorney. But
so no, wait a moment. When was she denied legal aid?
my lord, when she went through court, let me tell you exact. Because the only time that she was been able to obtain legal aid was when she would have applied the second time when she was making this application is when she was given it for her applications. I'm just going to go to double check. She applied in 2012, and she also applied in 2013 and was denied on both of those occasions. Now, I know that there was a point of contention in relation to her being able to prove her positions that were before the court. And my learned friend says that even in light of all of the things that she's saying, which there is no information that was supported, she has no claim that will be able to substantiate in the case in the court. But if we're looking at the limitation period based on the position that we took in relation to her application in 2013, she's well within her limitation period to bring her application for breach, period. Whenever she brought it. She was not out of time.
Well, if you're right on that, but that depends upon you having a claim
for breach of duty
against the state for what the clerk did on the instruction of the magistrate.
And that would be under the constitutional position, my lord, that there has been a breach of her right to bring a case. And so she may not have pleaded it in the proper manner or presented her case in the proper manner to the Supreme Court when they're striking out application. And so we're looking at a strikeout application on a flawed pleading, identified as flawed pleadings, and then acceded to as they were substantial pleadings. And we're now saying that there's no merit because her pleadings were flawed. And she's a litigant in person. That in itself should be a breach of natural justice.
This has been seen as a separate right of action for breach of the constitutional right to a fair hearing under Article 6. She could still bring that claim, couldn't she? Quite apart from anything else we have before us.
And but my lord, when would she would have made that claim? What I'm suggesting is that in her claim in Supreme Court, she's alluding to this. She speaks in her submissions, in her application of a breach of her constitutional rights. She may not have pleaded it properly. This is what I'm saying. Miss Pedro comes to court with all of these things on her documents to say that she's been wronged. She's been wronged. Okay. It may not have made sense as it was stated, but going through the information, substantial points of law are made within it and not backed up with proper information. I'm saying that she should have been given the opportunity by the judge. The judge should have stopped her on the spot and said, Ms. Pedro, you are out of your depth and you need to be represented by a counsel. Most judges do this. Most judges do this. You need to get a lawyer to assist you, and I'm going to adjourn this case on the spot. That is not what happened. My learned friend says in his position, says, I think it's fair to say that the essence of Ms. Pedro's claim, okay, wait, let me find the actual paragraph because I think I skipped it. Okay, and looking at Ms. Pedro's submissions and her response to my submission, she makes reference to several documents, letters, and evidence she claims she has. I think for the court's consideration, perhaps the application to strike out would be more appropriate after there has been disclosure in this matter because none of these documents have been exhibited. The court, I think, would be at a disadvantage in terms of assessing the value of any submission by Ms. Pedro unless it has been documents she intends to rely on and refers to in this matter. So, for example, and I note, and I'll just pause there, I know that when you have strikeout applications, all the evidence is not before the court. But so, for example, she says in her submissions as to why her application ought not to be struck out, she refers to letters written by Anisha Cott-Peets. She refers to documents which she says has on the file, on the court file, and I'm going through it now because I'm just seeing it. And in her response to me, which was copied to the Supreme Court at 5:45 yesterday morning, she says she makes reference to or makes averments that she made applications every year with regards to trying to help her son. And this is in relation to my asserting that she is under the limitation she falls on, the limitation, and certainly any evidence of these applications, I think, would be useful for her to promote her case. Now, we are looking at this in a deficient state and in light of the irregularities in my learned friend's application, and still saying that all of these things could be remedied by accepting the position that the court had, that this was either, yes, I accept that it was statute barred, is what they're saying, or that there's no ground for her to bring this case, and that it is vexatious, and that there is no point to this litigation. We cannot accept that at this point, because her case has not been brought properly in the first instance to determine that. And now we're going through this whole exercise at this stage to determine whether there's validity in her case. And we say, based on the information, even in the report, which my learned friend skips over, is that the report is indicating that she was completely in shock. Okay, even the only time that this Ms. Pedro was properly represented or had a representation was in 2000 and the 8th of January application. Where are the other lawyers? No other lawyers, but for when she got the legal aid application to make this application, and she still then did not get any support from the litigation bar to help her with the application. She had to file it by herself. So we can...
If I may briefly respond with your permission, my lords, what are we dealing with in this appeal? There was no application to amend pleadings. You know, I think we're going a little too far now. I think the point that my Lord Justice Smelly made is that, you know, this potentially new cause of action about exacerbation from 2013 and whether or not the actions of the clerk gives rise to a cause of action. That doesn't arise in the context of this appeal. And I think it is still open to Ms. Pedro to ask the court in an application to extend the time to permit her to bring a claim in that regard. And that can happen even after this appeal is dismissed, as we say it should. But certainly those are not issues on appeal before the court now. That is a new cause of action which was grasped at by my learned friend on basically the clarification that was being sought by the court as to what does this letter from the clerk mean and where does it fit in. It certainly was not evident in her claim that this would have been a separate cause of action. And so I don't think the court should consider it now in the context of this appeal.
I don't agree with that position. And the only reason why I say that is that Miss Pedro would have made representations in her application of a breach of her constitutional rights and being able to get to a fair trial. And she goes on and on about everything that happened to her, inclusive of her not being able to bring the application when
Is there
she was
any time
denied.
limit for an application for redress under the Constitution?
Well, I was, when you say redress, my lord,
Under Section 15, which provides that if any person alleges that any of the foregoing provisions of this chapter have been or is being or likely to be contravened, then without prejudice to any other action with respect to the same matter, party may apply to the Supreme Court for redress.
I don't think there is.
Not barred by
could be in a limitation.
section 4 of the Limitation Act, which speaks only to claims in tort.
Certainly.
And but my lord, I would say that I mean, my learned friend is saying, and now in the position that an application should have been made on below the court in order for her to have gone through this process to properly amend her pleadings. But remember, when she's going through this process, again, she's litigant in person. She doesn't know the rules of the court. And did at any time do you see that any of Ms. Wheatley bring to her attention any of the proceedings or the policies or what should be guided by? She was even ambushed by the limitation point and having to answer it later on by my learned friend's failure of actually pleading it. And so again, we're treating her like she was an attorney throughout this process when she wasn't. She has never been properly dealt with, to me, in my position, in my opinion, my lord, by the court, and given guidance as to how she should proceed herself, especially when we're dealing with this Supreme Court application. This appeal was really based on two folds. Was it that the judge's position should we follow the de facto position and say that we accede to her position? And the points in relation to that is that first and foremost, these judges and registrars are to take oaths, and it is automatically acceded that this happens in conjunction with them signing their authorities, okay? And that is the process by which all of the judges affect. If you recall how you would have become Court of Appeal judges, and they even swear allegiance to separate oaths. So there is an oath that is sworn by the registrar that is under one legislation, the Bermuda Constitution. The
Promissory Oaths Act.
Correct.
No, it's not as the registrar, yes. Yeah.
No, the registrar, as far as the registrar. So she's sworn under that
Supreme
act.
Court Act, I think.
And it's actually called the
Promissory Oaths.
Promissory Oaths Act. And
Yes.
the Supreme Court justices are sworn under the Constitution. So their offices, they're not even governed by the same legislation. But yet we're suggesting that the de facto judge point should follow and point to say that she should be accepted, or anything that she does should be accepted and given credence to based on this de facto judge. When clearly the position that was espoused in the case, in the Jamaican case, in Paul Cheng Young, was that all the nullities would have occurred in light of all the positions of the de facto judge. And so how do we deal with this issue? We're talking about how do we right the irregularities that have happened in the previous. And if we are going to accept all of the irregularities, I don't think that is what the court's position could be under the circumstances. There has to be some idea to right all of the wrongs of this case. The ultra vires, the irregularity of my learned friend's pleadings, the irregularity of my client's pleadings, just irregularity of the proceedings, and all of those things that have transpired that has caused her to reach this point in this Court of Appeal application. And the only way to do that is to allow her to go back to the Supreme Court, amend her pleadings, put her case forward, and deal with it on the merits, and not throw it out today because of missteps by her being a litigant in person. and fatalities that my learned friend says exist, but there is obviously proof of the otherwise, particularly in relating to her damages and particularly in relating to what she suffered. And in light of the fact that the report, even though it came in 2020, does say that this woman had been suffering from shock, and that in itself is debilitating enough, I say, for her to have only acted in the way she acted. She only can do what she knows. She's not a lawyer. And she's been acting by herself since then, up until Mr. Hill came on the record, and now I'm on the record for her in relation to this application. So it's really for the court to determine at this stage, should the wrong be righted and allow this woman her day to justice, or to at least put forward her case in the best manner that she can in order to obtain the right to make such applications to the court and make such claims, which I say she's well in her right to do so.
Right. Well, thank you very much. It won't surprise you to learn that we will take time to consider our decision, but we will endeavor to give that as soon as practicable.
Thank you very much.
Thank you, my lords.
Thank you.
Thank you.
We'll go into